Deputy Chief Justice, may it please the Court, I appear for the appellants in these appeals together with my learned friends Ms. Hofmeyer, Ms. Mkandi, and Ms. Creyer.
May it please the Court, I appear for the respondent together with my learned friend Mr. Mkiwa.
Thank you, Mr. Director. Please go ahead.
Deputy Chief Justice, before my stop clock starts, might I briefly raise a procedural matter which has only just arisen in our discussion with you before the hearing, and that is that we learnt that a note pertaining to foreign law had apparently been filed with the court by the respondents some time ago. Unfortunately, that note did not make it to our side at all. So we don't know of it, we haven't seen it. My address will not deal with it, obviously, in those circumstances, and we will need to deal at some point with how practically, if necessary, we deal with it. But I say that up front so that the court is not surprised if I don't deal with aspects that appear in that note.
No problem. Thank you very much. Please go ahead. You know the betting order. It's 30 minutes.
Yes, as the court pleases. This appeal involves the lawfulness of income tax assessments imposed on the appellants pursuant to the general anti-avoidance principles in sections 80A to 80L of the Income Tax Act, commonly referred to as the GAR. The appellants Absa Bank and United Towers are fellow group companies. Save for dates and amounts, their cases are identical. For simplicity's sake, we refer only to Absa. Absa asked this court to set aside a decision of the Supreme Court of Appeal and to confirm the order made by Sutherland ADJP in the High Court on the 11th of March 2021, in which he reviewed and set aside the SARS assessments. The review was based both on the Promotion of Administrative Justice Act and the principle of legality. Two procedural hurdles to this appeal were cleared in this court's prior judgment of the 31st of March this year. First, Absa was granted leave to appeal against the judgment of the SCA. And second, Absa was granted the necessary direction to proceed with its review in the High Court in terms of Section 105 of the Tax Administration Act, or which I'll also refer to as the TAA. The path is therefore clear for this court to devote its undivided attention to the merits of Absa's review. The GAR provides SARS with an extraordinary and, we say, invasive power. It permits SARS to subject an entity to tax where the ordinary rules of the Income Tax Act, properly construed and applied, would not permit this. While we accept that the GAR has a place in the tax administration toolbox, such a power carries clear dangers. Its ambit must therefore be carefully and clearly circumscribed. Absa contends that in making the disputed assessments, SARS overreached the bounds of the GAR power. The review before the court is not exhaustive of Absa's complaints about the assessments, but it should dispose of the assessments because they're vitiated by two material errors of law. Absa says, in short, that the factual substratum on which SARS based the GAR assessments cannot, for two legal reasons, justify those assessments. And as this court has already held, Absa's complaint is akin to an exception in civil practice. We say that the lawfulness of the GAR assessments is tested by reference to the facts on which the GAR power was exercised. The source of those facts is the letter of assessment dated the 17th of October 2019, which the court finds at pages 347 to 368 of the record. Matters averred by SARS in its affidavits or in the review or in the application for leave to appeal or indeed in its heads of argument cannot ex post facto alter or expand that factual matrix. We say the legal competence of the assessment for purposes of the review stands and falls by the contents of the letter of assessment. Absa contends that the assessments received by it are unlawful because they issued in the face of two core facts as reflected in the letter of assessment. The first fact is that while SARS has based its assessment on an arrangement involving transactions between a wide cast of entities, Absa understood only that it was investing in preference shares issued by PSIC3 and in agreements securing that investment, that those funds would be used by PSIC3 to invest back-to-back in preference shares issued by MSSA, and that MSSA in turn would use those funds in its South African broker operations. SARS, on the other hand, has identified complex downstream transactions between inter alia PSIC3, PSIC4, the D1 Trust, and MSSA that it contends resulted in tax avoidance. SARS does not say that Absa knew of these transactions, nor does SARS aver that Absa could or should have known of those transactions. It's content to assess Absa under the GAR with that factual underpin. The second fact is that within the identified arrangement, there was only one anticipated tax liability avoided, which was a tax liability anticipated by the so-called Macquarie entities and not by Absa. And what this court must decide is whether the following astonishing proposition we say made by SARS can be correct, that the GAR provisions can lawfully be applied to assess Absa for tax based on a tax benefit which it did not receive, of which fact it had no knowledge, and which arose from transactions of which it was not even aware. And we contend that the answer is plainly no. The court described the two legal errors on which we rely as the party error and the tax benefit error. Both are independently fatal to the assessment. Absa presses them both. It, however, only needs to succeed in one for the assessments to be set aside as unlawful. Conversely, for SARS to prevail, it must persuade the court that neither legal error exists. And I will deal with them in the order of the tax benefit error and then the party error. The tax benefit error's foundation, as I've said, is the accepted fact that an entity or entities other than Absa avoided an anticipated liability for tax in the identified arrangement. The established authorities referred to in our heads of argument, primarily King, Smith, and Hicklin, show that avoiding an anticipated liability for tax is the only factual path to establishing a tax benefit for GAR purposes. And SARS is alive to the devastating consequences, we say, of this fact for its argument. Therefore, in its affidavit, in the leave to appeal application, and in its heads of argument before this court, it mounts a rearguard argument that on a wide reading of the letter of assessment, the averment is made that Absa obtained a tax benefit. But this is false. As a matter of fact, there can be no tax benefit without an anticipated tax liability. Nowhere is it alleged that Absa anticipated a tax liability of its own. Indeed, the contrary is expressed. I quote, SARS says, the anticipated liability avoided was anticipated by the Macquarie entities and not by Absa. Imprecise and emotive statements elsewhere in the letter, such as that Absa received substantially all of the tax benefits created by the arrangements, can't, in our submission, help SARS when they're not supported by a factual allegation of an anticipated tax liability. All that they can mean is that Absa obtains some financial benefit, but that is not a tax benefit. So that SARS argument can safely be disregarded. So too, we say, can SARS's argument that Absa had a tax benefit when you compare its actual tax liability under the preference shares, which was zero because they were exempt in its hands, with the tax liability that it would have had if it had advanced an interest-bearing loan directly to MSSA. Nowhere in the assessment letter does it state that Absa anticipated advancing a loan at interest to MSSA. It's simply not part of the assessment. It has no place in the analysis. So with those factual distractions put up by SARS jettisoned, as we say they must be, we can return to the sole relevant question, whether Absa can in law be assessed to tax under the GAR despite it not having obtained a tax benefit as understood in the GAR. And we submit that on a sensible, textual, contextual, and purpose of construction of the GAR provisions, it cannot be so assessed. On the other hand, SARS makes the only argument it can to try to save the assessments, namely that it does not matter to substantiate an assessment against Absa that Absa did not itself obtain the benefit, as long as a tax benefit is found to exist somewhere within the assessed arrangement. And the way SARS formulates its argument in this regard in the heads is to say that the entity to which the tax benefit accrues is entirely irrelevant to determining whether an impermissible avoidance arrangement exists. In this, however, we say SARS is entirely wrong. The identity of the recipient of the tax benefit is central to the application of the GAR. And to understand that, I should say something briefly about the structure of the GAR, the textual structure. Section 80A provides the overarching formula for what constitutes an impermissible avoidance arrangement. Section 80B then intervenes in the statutory sequence to provide for the Commissioner's powers in the face of such an arrangement. Then sections 80C to 80H, read with statutory definitions, give content to different aspects of the Section 80A formula. So to know what is an impermissible avoidance arrangement, one must read Section 80A together as a unit with sections 80C to 80H and the definitions. The work, the statutory work that Section 80A does, is to convert what is objectively an avoidance arrangement into an impermissible avoidance arrangement by the addition of two further components, a qualifying sole or main purpose and one or more so-called tainted or tainting elements. And an avoidance arrangement, which is the starting point, is defined as any arrangement that but for this part results in a tax benefit. And as we know, a tax benefit is separately defined in Section 1 to include the avoidance, postponement, or reduction of any liability for tax. The word liability, we say, is important. A liability doesn't exist in the abstract. It accrues to a particular person. So Section 80A does not even start to operate until SARS has identified a particular tax liability that has been avoided. To do that, SARS must identify a person whose tax liability is avoided. Hence, the identity of the person obtaining the tax benefit is already built into the notion of an avoidance arrangement as defined. When SARS argues in its heads that the definition of avoidance arrangement does not speak of the tax benefit accruing to any particular party, again, it is wrong. That is implicit in the concept of a tax benefit, of an avoidance arrangement, sorry. So once the tax benefit and its recipient is identified, Section 80A, as I've said, adds two further requirements to make the arrangement impermissible. Absa's argument on this point focuses on the first of these, which is the sole or main purpose test. In other words, that the sole or main purpose of the avoidance arrangement was to obtain the tax benefit. I've already mentioned that Section 80A must be read as a unit with Section 80C and following. And in this regard, the sole or main purpose aspect of Section 80A is inextricably bound up with Section 80G sub 1. There is no impermissible avoidance arrangement without the application of Section 80G1. We say this because Section 80G1 provides for a presumption. It provides that an avoidance arrangement is presumed to have been entered into for the sole or main purpose of obtaining a tax benefit, unless and until the party obtaining a tax benefit proves that, reasonably considered in light of the relevant facts and circumstances, obtaining a tax benefit is not the sole or main purpose of the avoidance arrangement. Thus, Section 80G1 activates the sole or main purpose requirement of Section 80A. It does that through the presumption. The effect of that section is to turn an identified avoidance arrangement automatically into an impermissible avoidance arrangement unless the presumption is rebutted. And crucially, the only entity that is statutorily mandated and capable of rebutting the presumption is the party obtaining a tax benefit. No other entity can do so. The statutory language is clear. Thus, contrary to SARS's submissions, the entity to which the tax benefit accrues is of central relevance to determining whether an impermissible avoidance arrangement exists at all. Because firstly, its anticipated liability is what gives rise to an avoidance arrangement in the first place. And secondly, that avoidance arrangement is only elevated to an impermissible arrangement because it has not put up facts to overcome the presumption. In this regard, we say it's highly significant that Section 80G1 uses what I could call forensic language. It refers to a presumption of purpose that can only be displaced by the entity obtaining the tax benefit proving a different purpose. That language presupposes that SARS and the entity obtaining the tax benefit are necessarily standing opposite one another in a tax dispute, one that may ultimately be resolved in court. And since a tax dispute cannot arise without a tax assessment, this demonstrates that the assessed party under the GAR must be the one obtaining the tax benefit. So when SARS in its heads of argument says that Absa cannot identify the provision that requires it to establish that Absa was the one that obtained the tax liability, we point to Section 80G1 read with Section 80A. The two together make that point expressly. A finding that a taxpayer can somehow be assessed without it having obtained a tax benefit also, we say, offends the fabric of the statutory tax dispute resolution process, which one finds mostly in the TAA. That dispute resolution process commences, in a sense, even before there is a dispute. SARS must issue a letter of audit findings together with the grounds of the assessment, and the taxpayer can respond. That's Section 42 of the TAA. In the GAR context, there's a separate layer called the 80J notice, where SARS must do the same and the taxpayer has a chance to respond. Once there's an assessment, the taxpayer can object, and SARS can either allow or disallow the objection. All of those processes are purely bilateral processes. They exist between SARS and the taxpayer. There is no machinery anywhere in those provisions that gives the taxpayer the ability to engage with a third party to enable it to respond to SARS's proposed assessments. So if SARS is entitled to exercise the GAR power against a taxpayer that was not the one obtaining the benefit, the tax benefit, the assessed taxpayer's right to benefit from those processes is materially compromised. First of all, the taxpayer may be unable to deal with whether there's a tax benefit or not. Determining whether a tax benefit exists or not is a matter of some complexity, involving facts, counterfactuals, motivations, actions, all attributable to the person with the anticipated liability. The assessed taxpayer is at a fundamental disadvantage in engaging with those facts if it's not the entity with the tax benefit. Second, the assessed taxpayer is at a disadvantage engaging with a sole or main purpose criterion where it is remote from the tax benefit. But thirdly, and most crucially, because of the unambiguous wording of Section 80G1, the assessed taxpayer is legally powerless to displace the presumption of purpose. Only the person obtaining the benefit can do so. The taxpayer is doomed to being assessed and its objection being disallowed. And then by the time the matter comes to the tax court, there are still only two parties in the room, SARS and the assessed taxpayer. Tax litigation is a private affair between those parties. So again, where the person assessed did not obtain the tax benefit, the sole entity that the statute permits to rebut the presumption of purpose is not even in court. On SARS's approach, the taxpayer's hands are tied. We say that is inequitable and cannot be so. And the point that we want to highlight is that it's often said that statutory and common law presumptions are based on considerations of policy, fairness, and indeed of pragmatism. A presumption for which policy reasons makes it easier for one of the parties to come home on its case is recognized as legitimate where the relevant facts are peculiarly in the knowledge of one of the parties. And I would refer the court, it's not in our heads, to the judgment of Harkson versus Lane of this court in paragraph 59 and the SCA in the Bogoshi case. In the GAR context, there are understandable reasons to burden the party that obtained the tax benefit with putting up the facts to discharge the onus. Indeed, the Section 80G1 presumption is only overcome if the different purpose is found reasonably considered in light of the relevant facts and circumstances. So the entity that obtains the tax benefit is uniquely placed to present what is relevant. It's fair to place the onus on it. It is not fair to place the onus on a party that does not have access to those facts. And we say, effectively, the effect of specifying that only the recipient of the benefit can rebut the presumption is that where the person assessed is not that person, what was enacted as a rebuttable presumption becomes an irrebuttable presumption. That completely undermines, we say, the apparent legislative purpose. None of these difficulties arise, with respect, if one accepts, consistent with the express language of Section 80G1, that a GAR assessment can only be made against a party obtaining the tax benefit. What Parliament set up as a rebuttable presumption remains rebuttable by the party that is naturally placed to do so. And there's nothing unusual about that conclusion. This is how it's always been in the GAR. We referred in our heads of argument to Hicklin's case, where it was held that the liability avoided must be that of the taxpayer. We know of no reported case where the assessment was not directed at the person alleged to have avoided tax. And finally, in relation to the tax benefit error, we highlight briefly four other factors that support Absa's case. The first is that the GAR is a provision that targets tax avoidance. Assessing for tax a person that did not avoid tax does not remedy the tax avoidance. The manifest purpose of the scheme, the legislative scheme, is not met. The second factor is that if SARS is able to assess a taxpayer who did not receive a tax benefit, what it is actually doing is not recovering tax that was avoided, but punishing. The assessed person, we say, is penalized for merely being involved in an arrangement in which some other entity, somewhere else, obtained a tax benefit. And this court has held in the DA versus ANC case that courts should prefer interpretations of statutes that do not impose penalties over those that do, unless the legislative intention is clear. Thus, in the contest between SARS's interpretation and Absa's should be preferred. The third factor is that there is in fact a provision in the GAR which allows, in certain circumstances, a party that did not obtain a tax benefit to be taxed. And that is section 80F small a, which provides that where parties are connected persons to one another, SARS may treat those parties as one and the same person for purposes of determining whether a tax benefit arose. So there is a machinery to do that, but it does not extend to the facts of the present case because there was no connected party relationship between Absa and the Macquarie entities. And the fourth factor referred to in our heads is section 80B1F, which is the catch-all power of the Commissioner to determine tax consequences in such other manner as in the circumstances of the case the Commissioner deals appropriate for the prevention or diminution of the relevant tax benefit. Assessing Absa to tax, in this case, has no impact on the alleged tax benefit obtained by the D1 Trust or PSIC4. Neither prevents it nor diminishes it. It raises the possibility of a double recovery, once from Absa and once from those entities. This simply does not arise if the GAR is interpreted as we contend it should be. I quote from Schreiner J.A. in King's case in a concurring minority judgment, in which, in relation to the then GAR, section 90, he said that one must avoid giving it a meaning which, because of its absurd and indeed revolutionary consequences, the legislature could not have intended, and that a sphere of operation, reasonable and at the same time effective, must, if possible, be discovered for the section. We say that this is the exercise that this court must do in relation to the current GAR, which is no less drastic in its results. So in the circumstances in relation to the tax benefit point, we contend that that error is manifestly established and that the assessments are as a result unlawful. As regards the party error, we locate our argument in the defined meaning of the word party, which is a person who participates or takes part in an arrangement. We respectfully endorse the approach of Sutherland ADJP in the High Court, who found that participation or taking part requires volition and that a taxpayer has to be not merely present, but participating. It stands to reason that one cannot, on plain language, be held to participate or take part in something of which one is not aware. This is particularly so where participation is a gateway to material adverse consequences. Whether a person is taking part in something must, we say, necessarily be assessed from the viewpoint or perspective of that party. Its objective presence in something can never be enough. And what is important in the GAR context is that the term party is defined expressly with reference to the term arrangement, and those two aspects have to work hand in hand. SARS, with all of its powers of assessment and investigation, is empowered to select the arrangement on which it seeks to found the GAR assessment. But once it's done that, it has to be consistent. It must apply the GAR to all apply all aspects of the GAR to that identified arrangement. In this case, SARS has identified as an arrangement a series of transactions involving a number of entities making up what it calls a scheme. So for SARS to apply the GAR to Absa as a party, it must show that it was a party to that whole scheme with all of its components. And that, we say, can only be said if Absa took part in that scheme and knew of it. The word arrangement is expressly included. The definition of the word arrangement expressly includes the words including all steps in or parts thereof. So being a party to an arrangement necessarily means party to all of its steps. How one can be a party to something of which one does not know is unclear. And all of the subcategories of arrangement, scheme, understanding, etc., they all presuppose some sort of a meeting of minds, even if not a legally enforceable one. That also signifies volition, which presupposes knowledge. On the facts on which the assessment is based, SARS, we say, is unable to show participation by Absa in the identified scheme. We accept that Absa, as a subscriber to the secured preference shares, was party to an arrangement, but it was not party to this arrangement. Although that should by itself suffice to set aside the assessments on the party ground, we stress also that it is not some peripheral part of the SARS arrangement of which Absa was not aware. It is the very dimension of the arrangement that's alleged to amount to tax avoidance, which falls outside Absa's knowledge. SARS, we submit, only has one substantive point to make in response to Absa's argument, and this is what we could call the willful blindness point. It argues that if knowledge was a requirement, a taxpayer could be rewarded for cynically closing its eyes to facts which would reveal the fullness of the arrangement and its effect. But the cases which SARS refers to in its heads in support of that principle demonstrate that where knowledge is a requirement of liability, the law is not hamstrung by behavior amounting to willful blindness. Such behavior can result in a finding of constructive knowledge. If SARS suspects such conduct, it has extensive powers to investigate, and if it wants to, it can make the allegation. The GAR accommodates that possibility, and yet no such facts are assessed in the present case. There is no allegation that Absa should have known that tax was being impermissibly avoided downstream. It's not said in the letter of assessment that the preference share terms gave rise to an inflated or non-arm's length return. SARS's averments about inflated returns, which we find in the heads of argument, are drawn from the affidavits, not from findings of fact in the letter of assessment, where they should be if they're to have any role in the review. And finally, in this regard, we say that SARS's approach raises the possibility of no-fault tax liability. The mere making available of funds to a third party, whether or not on arm's length terms, could on that approach lead to a tax liability because of facts of which the funder was not aware, had no reason to suspect. An interpretation that avoids what we say would be those draconian consequences should be preferred. And so we say also that on this basis the party error is established, rendering the assessments unlawful. So in conclusion on the merits, we invite the court to take a step back and ask itself the question, can it ever be right that an extraordinary statutory tax liability can be imposed on the basis of an anti-tax avoidance provision against a person who did not avoid tax and was ignorant of tax avoidance, and where the imposition of that liability does not, in fact, remedy the tax avoidance? That answer must be no. And we say it doesn't take much insight, with the greatest respect, to see what has happened in relation to these assessments. Faced with the difficulty of remedying the avoidance it has identified at its source, which is remote to Absa, SARS has sought to claw back money from the person it might be regarded as viewing as a so-called deep pocket. But it has done so through a blatant overreach, we say, of the GAR power. Its conduct, we say, is unlawful, and the only proper remedy is to set aside the assessments. That is done by reversing the SCA judgment and confirming the High Court order, as Absa seeks in its review. The final point I wish to make pertains to costs. Absa claims the costs of the appeal, as well as those costs of the application for leave to appeal which stood over. And we contend that this case is of significance, significant enough to warrant the costs of 3 counsel. However, to the extent that Absa's case is unsuccessful, Absa claims buyer-watch protection against being ordered to pay SARS's costs based on the principles set out by this court in the New Africa case. We contend that those principles are comfortably established in this case. But of course, that will not arise if, as we say, should occur with respect, the appeal should succeed. Those are our submissions. Thank you, Deputy Chief Justice.
Thank you, Mr. Janesh. Just one question from myself. If we are in your favor, or we find in your favor, in respect of holding that Absa was not a party to the avoidance arrangement, is it your submission that where Absa received higher tax-exempt dividends, then would be the case had it not been for the downstream arrangements? Absa should keep all the profits and not be taxed at all. In other words, should an entity be allowed to profit where the profit is derived from what I would call unlawful conduct, even though the party may be innocent?
With respect, Deputy Chief Justice, the question is, does the GAR allow for Absa to be assessed in these factual circumstances? And the question as to what benefit Absa got, financial benefit, is not relevant to the question of the application of the GAR. The GAR does not include the words financial benefit. It does not include anything along those lines. All it seeks to do is to remedy tax avoidance where tax avoidance has occurred. So in this particular case, we say it is not, if the result is that the assessment cannot stand,
Yes.
then Absa does not pay tax. As it turns out, Absa never had to pay tax because it always ever invested in preference shares. Preference shares do not give rise to taxable income. And so it is not a situation where it somehow profited in an unacceptable manner. It got the return that it contracted for. If the ability of somebody else to pay at that return was affected by what that party did, that is not something that can be laid at Absa's door under the GAR. There have to be limits, and the limit is the point at which we've contended, namely that if there's no tax benefit, even if you can call it a financial benefit, if there's no tax benefit, that's where it ends. So, and I should just point out also, Deputy Chief Justice, that there is no averment, as I think I said just now, there is no averment, in fact, as a basis for this judgment, that Absa obtained something more than it should have been entitled to expect. There's no suggestion that the dividends that it was able to get were in any way not arm's length. All that is averred is that Absa somehow has received the tax, the benefit. But what that means is it's received money. And that money is something separate from the tax avoidance or tax benefit which occurred somewhere else in the transaction.
Thank you very much.
Thank you. Thank you. Mr. Yannis, just on that, as a follow-up, if the court rules for Absa, does this create a blueprint for tax avoidance where parties can claim ignorance of arrangements they profit from?
The answer is certainly not, Justice Mhlantla. The GAR is a very powerful tool, properly exercised. And properly targeted, it will achieve its objective. There are many situations where the GAR will apply. It is not a situation where just because, as it turns out, the GAR is not capable on its current terms of dealing with what SARS complains of on Absa's side, that somehow this is an open sesame to any form of tax avoidance. The very contrary is true. If SARS applies this correctly, it has a number of targets, if it's correct on its facts, about the tax that was avoided within the Macquarie Group. We don't know why it hasn't gone there. We don't know why that entity was not assessed, or those entities were not assessed. But that is where the target is, the way the Act is structured.
Absa being a big company, is it not standard practice for Absa to understand the full structure of the complex arrangement, financial arrangements? Who's going to be involved or in these kind of transactions? Because one is talking about huge amounts of monies
Yes.
to a
Yes, it's always important for any entity entering into a contract to adopt proper due diligence. But that is not the case that's before the court. It is not suggested that Absa closed its eyes to anything. It is not suggested that Absa did not exercise due diligence. In fact, the case is brought on the basis that it does not matter that Absa did not know. And so, as I said in my address, if it turned out that there was a case for saying that there was some smoking gun, some piece of information which should have caused Absa to look further, it's open to SARS to allege that and to say that, in fact, you can't benefit from your blindness because you created it. That is simply not the case we have before us today. And so it does not create any kind of precedent or does not even get into that question. That question can be answered on the facts of other cases, but we submit that that's as far as that can go.
Absa's argument is that it was not a party to the scheme. All that it did was was involved in the preference scheme.
All it did was it invested in preference shares. But what's important is that's not Absa's case, that's SARS's case. SARS's case is that Absa was limited to in what it actually did and what it actually can be said to have known of, to getting preference shares and getting a preference share return in the form of dividends within the range of the 3 or 4 agreements that it was a party to. SARS does not allege anything wider than that, and that is the basis upon which the exception type of review must be decided.
Perhaps my question is related to Justice Mhlantla. Somehow I'm stuck in trying to clarify in my mind what the purpose or the objective of GA. And the reason I'm stuck there is because I'm saying, if we then say Absa didn't know, and we accept that Absa didn't know, and I'm going to ask you, Mr. Janish, whether it's your case that there may have been a tax benefit, but you didn't know, or that there was no tax benefit. I'm going to ask you to please explain to me. But I was still explaining to you where I'm stuck in saying that if the whole purpose was to target entities that are involved in transactions like this, on what basis can we then say, in this kind of situation, Absa was not involved in a scheme that was meant to be targeted by GA?
So the point of the anti-avoidance legislation is, as the name suggests, to remedy avoidance of tax, which means, as the courts have found consistently, to avoid a liability for tax which is anticipated. So you need to, the extent of the operation of the GA starts off by asking, would there have been tax if you did not do something? And you, I mean the taxpayer that's assessed. If the answer to that is no, that's simply not where the GA can go. In a case like this, we don't know whether there was a tax benefit or not in the Macquarie hands because we're not there. But for purposes of this particular review, we accept that there has been an allegation of a tax benefit on the part of Macquarie. And we must accept that that is correct for purposes of assessing the lawfulness of the assessment against Absa. So yes, assume that there was a tax benefit, but at the same time accept that it was not Absa's tax benefit, and secondly, that Absa did not even know that that tax benefit was being obtained. If you look at it from that perspective, you see that it can never serve the purpose of an anti-avoidance provision to attempt to extract money from an entity that did not avoid tax. It does not mean that SARS is not capable of doing that, as I've said, targeted at the correct taxpayer. It has extremely wide powers to do that, but its powers end at this point. So Absa is not asking to be somehow treated kindly. Absa is asking this court to apply the law, and the law says that unless you can demonstrate that if it had not been for this transaction, Absa itself would have paid tax that it did not pay, then you can't apply the GAR. So it is not a question of giving somebody a free ride. It's a question of applying what is already an invasive test only to achieve its objective and not further.
What if Absa did get the tax benefit? Is your answer the same?
If Absa is properly alleged to have obtained a tax benefit, then one can't set the assessments aside on review. But there is no allegation proper that Absa obtained a tax benefit. It's not enough to say you enjoyed the proceeds of someone else's tax benefit. To be shown to have a tax benefit, you have to be able to show what tax you were going to pay, but you didn't pay. And that's why I've said in this particular case, SARS has had to create something which is not in the letter of assessment, which is to say, oh, you invested in preference shares producing an exempt stream of dividends. But if you hadn't done that, you would have loaned money directly to Macquarie, to MSSA at interest. You simply do not see that anywhere. If it had made that case, then we would have a problem in attacking it on an exception basis, because then it would have averred what it needed to aver, would probably be incorrect when one gets to the trial. But that averment is not made. So with respect, Justice Chiki, one can't decide this matter on any hypothetical basis involving Absa getting a tax benefit, because that simply is not the fact that's in front of the court.
Yeah, and I'm asking myself now whether there's any entity that will ever admit that they got the tax benefit.
Well, they might or might not, but for purposes of this matter, and in fact, when one reads the cases, in many of the cases under the old GAR, the tax benefit was accepted to exist. But the point is that in this particular case, the only question is, has the allegation of a tax benefit been made at all, properly? And the answer is no. So it's not a question of do we accept or do we not accept. The question is it SARS's case that Absa had a tax benefit? And we say it's not. And on that basis...
Simply because they got it indirectly.
They did not get
not because it was obtained indirectly.
They did not get a tax benefit directly or indirectly. What they got was money in fulfillment of a preference share obligation from a third party. Whether the third party got a tax benefit or not is irrelevant, because it's not averred that Absa itself got a tax benefit.
Thanks, Mr. Chair. Thank you.
Mr. Yanis, this side, on your left.
I beg your pardon.
I need to start with you right at the beginning for me to have a proper understanding of what this case is all about. There was this letter of assessment. Firstly, what did the letter of assessment say? How was Absa's response to the letter? What were, at that time, the common cause facts from which the premise of both SARS and Absa departed?
So the letter of assessment, as I've said, it's in the record. It's about 20 pages or so, and I obviously can't deal with...
Just a brief, because I have follow-up questions to that.
So essentially, SARS, having investigated the transaction not only by asking Absa questions, but clearly by asking questions of the Macquarie Group, developed an understanding of what had happened.
That there was a scheme.
They found a range of transactions which we accept link with one another. It's not if one looks at them objectively. And they found who the different parties were and what the terms of those transactions were. And the details of the transaction I'm not going to go into now. But what was then found, as a matter of fact, was that Absa's view, its filter of what was happening, was limited to those parts of the transaction to which it was an actual signatory, party in the sense of being a signatory. And that was an investment in preference shares and various security agreements to protect its return and also that it knew that what was going to happen was that there would be a back-to-back preference share investment into MSSA. MSSA would use that money in its broker operations. That is as much as it was able to say about Absa, and that is a fact on which this matter must be decided. The second aspect, which was made clear, was that there was only one entity that anticipated a tax liability, and that was one of the Macquarie entities, the D1 Trust and or PSIC4, which was effectively on a conduit basis. And so those two facts were central to the letter. And what SARS then said was, since we see an arrangement in which you play a role, objectively, it does not matter that anybody else was the one getting the tax benefit. We are going to treat you as the party that must basically fund the state coffers. And so that was, and the response that Absa brought to this was to bring this review. Subsequently, it has, as one knows, there were responses, there was an objection to the letter of assessment. That's all on hold pending this particular hearing.
During the internal document phase stage, Absa provided information about its lack of knowledge and not ignorance. Perhaps to stretch it a bit further, ignorance about the downstream or how the scheme cascaded downwards. And those facts, am I right to say that SARS, let me use the word, seem to have accepted that those were the facts?
Yes.
And if SARS accepted that those were the facts, did the case proceed on the basis that SARS accepted that Absa was unaware of the ramification of the scheme? In other words, according to Absa, its involvement in the arrangement only related to the investment in the preference shares.
Yes.
As to what happened downstream, Absa says, we're not aware about what the other entities did and whether there was a back-to-back.
That is so, and that is the basis on which Absa was assessed. The factual basis of Absa's assessment was it does not matter that you do not know. We accept you do not know, but it doesn't matter.
But if SARS says, when you invest in those preference shares, you expect a particular return or a dividend. And when you receive your dividend, it has traveled through many destinations and until it comes to you. Well, as a responsible taxpayer, wouldn't you ask, why now my investment in entity one has now traveled through various entities and it's now back to me with a higher dividend?
Well, that is precisely the point, Justice Matopo. Those are not SARS's allegations. That is not SARS's case. One does not find anywhere in the letter a suggestion that somehow Absa got more than it was entitled to expect on an arm's length basis. That's simply not the case. The case, you don't know what the terms were. You don't know whether they were arm's length or not. They could be the same terms as anybody would have issued in a preference share. So the fact is that is, in our respectful submission, a factual red herring. What's important is that Absa had a transaction to get a contractual stream of dividends, and it got that stream of dividends. And from a purely financial and commercial perspective, of course, if you invest in something with a third party, it doesn't bother you. It shouldn't bother you what the third party needs to do to pay you. You look to the third party for payment, to your immediate counterparty for payment. And that is what happened here. So it simply is not part of the case that there's some lacuna of knowledge that SARS, that Absa should have filled. As I said in my main address, if there was such a basis, it would be open to SARS to plead it. And I would venture to suggest that if there were a case pleaded for willful blindness and knowledge of a tax benefit, one would have difficulty coming home on a review on the party ground, because that would effectively, some sort of constructive knowledge would be averred, and that would help to fill that hole. But we simply aren't there, and so the court does not need to consider that.
But if SARS says, I hear what Absa says, our approach is we have to look at the sole and main purpose to establish that the party obtained a tax benefit. And in other words, that exercise, correct me if I'm wrong, you would have to look at the entire conspectus of the transaction. And if you look at the entire transaction, you would ask, the Absa in this position, what was its sole and main purpose? If the sole and main purpose would have been to obtain a tax benefit, you look at the indicia, the facts that establishes that sole and main purpose. And if that sole and main purpose is what you and I have said, you invest 10 rands, for example, you expect a return of a dividend of what, 50 rands, and now suddenly you have a whooping million. And what do you say about that scenario?
Well, I say that the court can't take that scenario into account on these facts, because that is not the case before you. If it is, and let me not suggest that I'm avoiding the question. If there were an argument by SARS that exactly is what happened, that there was an unusual inflated return, a non-arm's length return, a return that could only be explained in some nefarious way, then we would not be here today. But that is not the case that's in front of the court. The case in front of the court is not based upon any particular concern about that. SARS accepts lack of knowledge and does not aver constructive knowledge. But going back to the point about sole or main purpose, it's of course tricky, because the sole or main purpose is said to be the sole or main purpose of the arrangement. We contend, although it's not something this court needs to decide, that in fact it's a subjective test. The sole or main purpose of the person getting the tax benefit, whether that was to get the tax benefit or not, is the question. But for present purposes, the tax benefit is not in Absa's hands. And so Absa can't be asked the question, was the sole or main purpose of the transaction to obtain a tax benefit? Well, of course, it can be asked that question, because it's going to say, from its perspective, absolutely not. All it wanted to do was invest in preference shares.
SARS says, you and the other entities, you are all in the same line. We cannot delineate or separate Absa from DTI, PSI4, and Acquire. You're all the same part of the whole arrangement of the scheme. We understand and accept that you invested in preference shares, and when you look at a transaction, it projects that you'll get X, but down the line, the transaction morphed into something else. Would that be a fair assessment of the position by SARS vis-a-vis Absa?
Not in this case, because it would have to have demonstrated some form of knowledge. It can't do it purely objectively, because you remember that you are assessing a particular taxpayer which doesn't have knowledge of those aspects. So again, if there were a case made out for some form of collusion and knowledge, that would be a very different case from the one that's before this court. But this court has to start from the premise of the facts on which SARS has based its assessment, and those facts are not part of it.
Let me see if I'm able to wrap myself around this. Would a finding in favor of Absa state that what Absa did not do was, one, to get away, escape, prevent any anticipated tax liability, a la Smith versus Smith's case. So in other words, if a finding has to be arrived at that conclusion, in the assessment of the facts, where do we look at Absa at its initial stages and say, when the transaction was initiated with the investment of those preference shares, this is how and the stage at which we must assess its intention? Just want to get...
Yes, no, I understand the question. The question is to demonstrate, and I agree with respect that the test is, was an anticipated tax liability avoided? Now, you test that at the time, you test that as a counterfactual to what actually happened.
Yeah.
So you say, if it had not been for this arrangement, Absa would have been subjected to tax. Now, and the only way, and what that means is that Absa would have anticipated a tax liability that somehow didn't happen. So that would be the counterfactual. So at the point at which the contract is entered into, you ask the question, if this hadn't happened, what else would happen? Now, for that you need to have an anticipated liability. The assessment is based upon a positive averment that the anticipated liability avoided, which SARS has identified, was anticipated by the Macquarie entities and not by Absa. So one does not have, it's not a question of a finding of this court. It's a question of what is SARS's case. SARS's case does not tick the essential box, factual box, that can allow a conclusion that Absa got a tax benefit. So it's not Absa's fault, it's SARS's fault for how it has structured its assessment.
Let me conclude with a question that I asked myself when I was preparing. There are two, and I'll solicit your views on that. One, I asked, can an entity be subjected to GAR when it was not a person or a party that avoided an anticipated tax liability? One. Two, it spoke to what I have said earlier. It's how does one determine what tax has been avoided, at what stage? And then I asked the question, why not pursue the other entities, DTI Trust, as entities that are alleged to have received the tax benefit?
Yes, so in answer to your first question, the answer is it cannot be possible under the GAR to assess an entity that did not get a tax benefit and otherwise that did not anticipate a tax liability. The answer to your last question is we don't know why SARS has not gone after the other entities, or maybe it has. We just don't know. But the question is, as I've said in my address, tax litigation is bilateral. So what happens in this case is that SARS must independently justify its action against this taxpayer, irrespective of whatever else happens. But we do say it is rather surprising that Absa is the party that is facing the assessment, when on SARS's own version, it was not the party that involved itself in any mischief.
Well, finally, and let me solicit your views again on this proposition by SARS, that there is no obligation that each party had knowledge of the arrangement as a whole.
We say that that is inconsistent with the nature and the meaning of the word party, because party as defined means taking part in or participating in. So we say that participation involves volition, volition involves knowledge. So if SARS were to say it does not matter that you did not know,
Just go there. On participation and volition and knowledge.
yes.
You say participation involves volition and knowledge.
We say that to participate in something, one must there must be a degree of volition, of wanting to or knowing that one is participating or taking part in something. To know that one is taking part in something, one has to know what that is. And so the points flow from one another. Participation involves volition, volition involves knowledge.
Mr. Janish, I just want to deal with the tax benefit issue first. Do you accept that the definition of an impermissible tax avoidance arrangement, or the legislative provision is in 80A, which tells us when an avoidance arrangement becomes an impermissible avoidance arrangement?
Certainly.
Where in that section 80A does it talk about any party? I'm not talking about 80B, please confine yourself to 80A.
No, it refers to an avoidance arrangement, but as I said, you have to then read it, populate it with the rest of the section.
I must be populate a legislative provision which is clear on the face of it.
Because you
To
cannot,
me, it's unequivocal.
you cannot understand Section 80A without seeing the other provisions which feed into it.
I understand it.
Well, with respect, you wouldn't be able to know how to decide what the sole or main purpose of the transaction was until such time as you'd applied Section 80G.
Yes.
You wouldn't know what constituted, for example, if I'm just looking at lacking commercial substance in whole or part without referring to Section 80C. You would need all of those aspects to populate your understanding of Section 80A.
Let's agree to disagree. You see, in your written submissions, I didn't hear you repeat it today, but correct me if I'm wrong. In your written submissions, you make reference to 80B, but 80B has got a completely different purpose. Do you accept that?
Well,
It's got the purpose of, once you've identified in 80A when a avoidance arrangement becomes an impermissible avoidance arrangement, what are the consequences? Do you accept that?
Yes, obviously. Yes, as I said, 80B contains the power that what SARS can do about an impermissible avoidance arrangement. But first it has to find that there's an impermissible avoidance arrangement, and that means it has to apply 80A together with its supporting provisions elsewhere in the GAR.
Well, as I've said to you, for now, I mean, you can persuade me, but for now, I don't see it like that. I'm looking at 80A, and it says to me the following. It says to me that an avoidance arrangement becomes an impermissible avoidance arrangement if the sole or main purpose was to obtain a tax benefit, and then it explains it in the context of business 1, 2, and so on. Do you accept that that's an objective test purpose? It's got nothing to do with subjective views of a taxpayer.
No, we don't accept that, Justice Majid. It's not a point that's been argued fully in this matter as to whether it's a subjective or objective test. There's a lot of case law that goes back to in previous iterations of the GAR which provided that it was a subjective test, and that is generally how many of the commentators see it, and one day a court will have to decide that point. But for our purposes of this matter, that's not an important consideration. What's important is to determine in this particular case whether there was an impermissible avoidance arrangement by reference to the party that is being assessed. And we contend that that is, as I've already mentioned, that is baked into the mechanics of Section 80A through the rebuttable presumption in 80G, that it can only be a party that obtains a tax benefit that can do the work that has to be done to avoid an automatic elevation from avoidance arrangement to impermissible avoidance arrangement through the sole or main purpose criterion.
So you and I differ on this. You say it can only be understood to refer to a party. I see it differently. I see that it's the arrangement here that is at the crux of this impermissible avoidance arrangement. Now, let me just say this before I give you a chance to respond. You accept that this particular section, or let me first backtrack. Am I right that this judgment by Sutherland DJP is the first judgment on GAR as amended in 2006, or are there others? No.
There have
Just off the
been
top of your head, you could.
there have been judgments dealing with peripheral aspects, procedural aspects, etc. But yes, on a pure merits basis,
Yes.
it is the first one.
Substantively, this is the first one. Now, do you accept that that section 103, I think, of the previous Income Tax Act version had the same provision, except for one important difference? That is that this section now creates a presumption later on. I think it's 80, you'll help me there, 80G creates the presumption. Do you accept that?
No, because in fact, Section 103 did also create a presumption. So Section 103.4, which unfortunately we didn't put into our heads of argument, but is relevant.
103 sub 4.
103
Let me
sub
just get
4.
there. 103 sub 4, you say?
Yes, and I'm going to try and just find it, to read it to the court.
Yeah, I see it. Yeah,
Oh, yeah, I'm going to find the actual.
yeah, it is there. You don't have to read it. I've got it. Thanks.
So that, and I want to make a point about that because it is an important thing to highlight. That presumption, which was a presumption of purpose, did not follow the words that are followed in Section 80G1.
See that, yes.
In fact, what it says is that whenever in the proceedings it's proved that the arrangement or whatever would result in the avoidance or postponement of liability for a payment of any tax, it shall be presumed until the contrary is proved that its sole or one of its main purposes was avoidance, etc. What you do not see there are the words which are now included in 80G. Entity obtaining the tax benefit proves. So if anything, what has happened is that the legislature has identified the essential requirement of discharging that onus or rebutting that presumption as being something that vests only in the person getting the tax benefit. Under the old statute, it wouldn't have been important, but now it's in black and white.
And can I understand that that is why you say it is important that it be a party?
That is so, Justice.
You use this argument.
In fact, the submission is that the only way one gets past that is to treat those words, the person obtaining the tax benefit, as pro non scripto, which a court, in our respectful submission, will not do.
Now, I must tell you I'm concerned about this interpretation. Both parties here agree that the purpose of GAR is obviously to counter this avoidance arrangements which are classified as impermissible. On your interpretation, it harks back to what my brother Matopo J and maybe one or other of my colleagues have also asked you. It would seem to undermine the entire purpose of the provision, which is to counter this kind of avoidance. And some academic writers in the articles you will know speak of the black box, where, these things happen way downstream. You have like 4 or 5 or 6 or even more interposing parties. You lend the money, you say, I think this is a back-to-back transaction. I'm blissfully unaware of all these other downstream transactions because I choose to be unaware. I don't know what's going to happen down there. But when the windfall comes, Brazilian bonds, surprise, surprise, double taxation agreement, surprise, surprise, we'll accept the windfall gladly. And for the rest, we didn't know what's going on there and we don't want to know. See, it does seem to me to be cynical, and I'm not accusing your client. I'm just saying, generally speaking, it seems to be a cynical, and excuse the pun, avoidance of what the legislature is trying to achieve here. How do we deal with that? How do we counter that kind of of perspective or dissuade me from that perspective.
Yes, well, with the greatest respect, Justice Majid, that is an example of reasoning a conclusion by reference to the conclusion one wants to reach. In this particular, the question, obviously there's an intention to expand the power of the legislature and of SARS, so expand the power of SARS, to be able to impose tax in situations where on the actual application of the tax laws one can't apply it. But for that, that power has to be circumscribed. And so the complexity of the GAR, you will see as time has gone on, if one looks back in our heads of argument, we've quoted the old Section 90 portions of Section 103. As time has gone on, the GAR has become more and more complex. And it's become more and more complex because it needs to be more focused on what actually is being challenged. So the answer to the question is, if it were unimportant that the person didn't know what was happening downstream, then one wouldn't have this word party that's defined as participating or taking part. If it wasn't essential that the party who is attacked is the one getting the tax benefit, one would not have the provision of avoiding or, anticipating a tax liability and the reverse onus provision that has now been instituted. So it's a question of what is the proper ambit of the language, remembering that one can't simply say, I'm going to tax you because I feel you should be paying tax. That would be contrary effectively to the rule of law. It has to be kept within particular bounds, and I should point out, as everyone knows, that SARS is almost uniquely placed to be able to persuade Treasury and thereby to persuade Parliament to tailor legislation to suit it in a way that ultimately helps it to get more tax. Non-constat that one should say that these provisions must be broadly interpreted contrary to their own language. It's not setting some sort of a precedent, it's not sending some sort of a message. In fact, the message this court should be sending is that even within the GAR context, predictability is key for commercial and economic progress. Entities must be able to know what they can do, and they must be able to know what the dangers are. And where the statute is interpreted in a way that makes it impossible effectively for a person to protect themselves, that is a bridge too far. So again, I said, if a case were made out for collusion, we'd be in a different world. But we're not in that world. And so any decision this court makes upholding the appeal is not, and upholding the review, is not making broad statements about a charter for tax avoidance. It's in fact saying if SARS wants to attack tax avoidance, it must do it within the realm of what it's got.
Just turning then from the tax benefit to the second alleged error that you rely on, which is the fact that it couldn't be a party because it had no knowledge. I'm just looking at the definitions in section 80 capital L.
Yes.
When you look at the definition of arrangement, it's quite wide, isn't it? Well, let me just ask you this. Sorry, it slipped my mind. I mean, you may comment on it, but you don't have to. The respondent says in the written submissions that you didn't press this point very hard in the previous hearing we had. You run your case the way you deem fit, but I take it you are still relying on it.
Yes.
Because you only need one. But
Yes, as I've said, for that case, it sufficed for us to make that point to get over the jurisdictional hurdle. We pressed both points equally.
yeah. Now, what do you say about this wide definition of arrangement in section 80L? And with that, that party means any person who participates or takes part in this widely defined arrangement.
Yes, so the word arrangement is widely defined, which gives SARS flexibility. But the point is that SARS must choose the arrangement to which it is going to apply the GAR. So it can look at a wide conspectus of facts. It can say, I know that there were 20 parties involved, but I'm selecting these 4 transactions where I see tax avoidance, and this is what I'm going to apply it to. And the question then is, who was a party to that identified arrangement? It could go wider, it could go narrower, but when it's made its choice, it's bound by that choice. So what we say is that arrangement gives flexibility for SARS to pick its target. Party means that you then have to demonstrate connection, volition, in relation to what SARS has selected. And so SARS has incredible powers to do that. It's not for the taxpayer to say, no, this wasn't an arrangement. SARS can say what the arrangement was, but then SARS has to pull through on all aspects, including the party, the party requirement.
Now, you will know as a lawyer, just generally, but more specifically here, how difficult it is to ascribe knowledge to a party where the facts are within their own peculiar knowledge of that particular party. So the best you can do as a trier of fact, you sit here as a trier of fact, you're a judge or a magistrate, you are asked to draw conclusions based on constructive knowledge. Now, as a lawyer, you'll understand generally that's a very, very difficult exercise. I'm worried again. I reiterate my previous concern in a different context, this one, the second one. It worries me that if this is the approach we take, and I'm just putting it out there, I'm not saying that is my view. Prima facie, it seems to me that if that's the approach that we adopt in this case, it denudes and defangs the GAR provisions almost completely. I mean, SARS it would be a long way to go for SARS to get a court, a trial of fact, attribute this constructive knowledge, where they have no knowledge of the facts are in fact lay with the taxpayer and the other downstream parties.
Well, with respect, Justice Majidi, of course, every case will turn on its own facts, and the advantage that SARS has is it doesn't come as a complete stranger to the transaction once it's gone through its investigating powers. It's got wide investigating powers, and it can require the taxpayer to produce all sorts of information. So it's not sitting there with its hands tied behind its back. But what it's important to do is, what's important to note is that, number one, the difficulty that a SARS or a trier of fact may have in relation to aspects that are peculiarly within the knowledge of the taxpayer is resolved by the reverse onus in Section 80G. So as long as you've demonstrated a tax benefit, if that entity does not come to court and explain what its purpose was, then it's going to lose. And it makes sense for that to happen because that is the entity that can describe what its intention was. So there's no real disadvantage to SARS. In fact, the advantage is with SARS and with the trier of fact, who can sit back and say, you didn't get over that hurdle, you don't discharge the onus. But to say that in a case like this, and again, the second part is that it's possible for SARS to say, I see enough facts here to know that the smell test is not passed. There must be more that you knew or should have known, and I'm going to incorporate that in my analysis of the transaction. Again, it's not a question of what should or should not be found. It's a question of what SARS has chosen to allege in this case, and it has not chosen to allege anything like that.
Just to conclude this, my last question concerns the question of costs, which is, in this big scheme of things, a minor issue. But let me just conclude on this. What we have here, and you say each case must be decided on its own facts. Obviously, that's true. But what we have here is Absa funds this, and I'm just calling it a scheme for now. Please don't take it in the context of this that I see it as a scheme. But in this whole scheme, Absa funds to the tune of about 1.2 or 1.3 billion rand.
Something like that.
Several parties interposed, and at the end, there's an investment in floating Brazilian bonds, which income derived from there is in terms of the double taxation agreement, tax exempt. Work flows back, income flows back, and the loan is repaid, and there's no tax exemption for Absa. Just on the face of it, Mr. Janij, I understand you act for the taxpayer, but just on the face of it, if you're sitting as an adjudicator, as a tax court or as a tax or appeal like this, it does seem that there is something rotten in the state of Denmark in the transaction. And then all the taxpayer says is, well, you know, I funded this bona fide. I wasn't interested in what happens downstream. I just want to get my money back. I got my money back, and I got a tax exemption windfall. That's just par for the course.
Well, with respect, it didn't get a tax exemption windfall. It invested in a product that produced exempt dividends in terms of the ordinary provisions of our Act. That is what a dividend is. And
You said that was all just fortuitous.
no, it was intended to invest in a preference share. And the way these things work, if I could give a bit of context, is that obviously within financial organizations and banks and so forth, there's always a symmetry between money in and money out. And so you'll never find a situation, for example, where an entity like Absa will buy a preference share using money that it's borrowed from someone, because it could never deduct the income, deduct the interest it pays, because it's not in the production of income, because a dividend is not income. And likewise, you wouldn't find it the other way around. So in this case, it's a preference share business. They raise capital through issuing their own preference shares or their own ordinary shares, and they invest that in preference shares, and the benefits equal out from a tax perspective as well. Nothing unusual about that, and SARS has not got a word negative to say about that. So there's no windfall involved. But what's most important here is you say something is not right in the state of Denmark. Well, if there is a problem, Denmark is Macquarie. And to say that Absa somehow funded that is making a number of leaps of logic, because all it did was buy preference shares. And whatever happened down the track, monies are fungible, it can do whatever it wants, but from Absa's perspective, it invests in preference shares and it receives dividends. And there's no suggestion that it should have known any different. So on these particular facts with respect, if those aspects are not alleged, there can be no GAR liability.
Yeah, I don't want to be facetious, but I suppose the counter-argument is that's why preference shares were chosen. But anyway, let me ask you about cost. Why should we allow cost of 3 counsel here? Much of the dispute was decided in the earlier judgment was given in the 5 tax cases, which was the question of the Section 105 argument and so on. Why do you need 3 counsel to come and argue these far more narrow points? Surely you can't, if you're successful, you can't litigate in this luxury at the expense of the taxpayer. That's us sitting here, you standing there.
Yes, with respect, Justice Majid, the team was kept together from the previous hearing. In the previous hearing, we had to face a costs order against us in relation to certain aspects.
That's your choice, Mr. Janish. If you want to keep the team together,
it is a choice.
No problem with that, but you pay for it.
No, it is a choice, and it's not a point. It's not a point that we pursue with. No, it's not a point that we pursue with any vigor.
If you are unsuccessful, why do you deserve buyer-watch protection? Surely this is a purely commercial dispute.
Well, if I could just ask the court to have regard to the New Africa case. I'll just quote from New Africa. If the court will just give me a moment to find it. Sorry, I should move to paperless world.
The same difficulty, Mr. Janish. I'm old school. I like paper.
Yes. Paragraph 149.
The DCJ is glaring at me because he doesn't want me to say that.
Yes, well, I finally found it. Paragraph 149 of New Africa says that the ordinary rule is that costs follow the result, and the unsuccessful party must pay the costs of the successful party. Even though the retailers were unsuccessful before us, they should enjoy buyer-watch protection, despite the fact that they are pursuing a commercial interest. In essence, their case was about a review application which concerned the control of the exercise of public power in terms of the principle of legality and parja. Clearly, they were seeking to vindicate their constitutional rights. The applications were not frivolous or otherwise inappropriate. We say that every one of those boxes is ticked in our matter. Absa is indeed pursuing a commercial interest because it does not want to have to pay the tax that has been imposed on it, but the case is about a review and it's about the proper extent of SARS's powers under the GAR. There's nothing frivolous or inappropriate about the application. In fact, a court has already decided, the High Court already had decided the matter in its favour. So we submit that this falls squarely within paragraph 149 of New Africa.
Except that New Africa did concern declarations of constitutional invalidity, which is an important point of distinction, not so?
Yes, but we don't ask for that, but of course we're in a position where, as this court as the highest court to deal with matters, including matters of review, is dealing with this constitutional issue by definition, it being a review.
Thank you, Mr. Janish. Thank you, DCJ.
Mr. Janish, early on in your submissions, and I'm not sure if I understood you correctly, you said that it was SARS who was alleging that it was a back-to-back purchase of preference shares. Is that not what Absa is saying the agreement related to?
That is what Absa says, but for purposes of the construct of this hearing, which is what is the factual basis of the assessment, SARS bought in to what Absa had said. And if I can just ask the court to note in that context where this is dealt with. I'm sorry, I will find it in a moment, Justice Turum. Yes, sorry, it's at page 351 of the record, paragraph 18. And in particular, I'm going to read the third line. In all four cases, Absa's understanding of the arrangement appears to be that the arrangement consists of back-to-back preference share investment into MSSA via PSIC3, which investment would be used to fund MSA's broker operations. None of the Absa documentation makes any reference to PSIC4, the D1 trust, or any of the other transactions. SARS has been advised by Absa and United that they were unaware of the unreferenced entities or transactions. And so, as Justice Rogers said in the previous judgment, SARS has itself decided to proceed without making the averment of knowledge and, in fact, making a positive averment of what Absa understood.
But Absa's case is that it was indeed a back-to-back purchase of preference shares. I'm just trying to understand that.
Its case is that is what it understood it was participating in. It turned out it wasn't, but it didn't know that.
Would there have been a tax benefit to Absa into entering such an agreement?
With respect, no, because for a tax benefit to exist, you would need to know that Absa anticipated other tax liability which it got away from. There is no, and what that means is there's a counterfactual. The courts have always, Hecklin, etc., have always said, look and see what would otherwise have happened. So in this case, there would have to be an averment that Absa would have taken its money and invested it in something that was going to realize taxable income. But that's just not the case. It's not in front of the court.
Would Absa have been able to apply for an exemption, tax exemption, in relation to the back-to-back preference share agreement?
Absa is entitled to an exemption by virtue of investing in a preference share. All it looks at is its own preference share. Now, there is a provision, I think it was Section 8E, which requires certain other aspects to be fulfilled, otherwise one could lose the exemption, but there's no application per se for an exemption. It follows automatically from the nature of the transaction entered into.
And was Absa granted an exemption?
Well, Absa didn't have to be granted it. It was entitled to the exemption and it had it.
Was granted the exemption by SARS?
Yes, it was precisely for that reason that SARS says that Absa did not pay tax and therefore avoided tax.
Can you please just explain to me, how does Absa say the but-for test should work?
We say that it should work by reference to a credible alternative. So let me just start off by saying that the vast majority of cases where the but-for test has applied have been situations, it's quite a common situation, where a taxpayer, let's say, holds shares, or in the Meyerowitz case, holds intellectual property that can produce royalties or whatever. And the taxpayer knows that if that does nothing, in due course, income is going to emerge. And so what it does is it disposes of that capital asset to someone else for the purpose of ensuring that it doesn't pay tax. And so the answer to that is, but for your disposal of that asset, you would have had a tax liability. So it always requires some form of hypothetical analysis of what would otherwise have happened. And that is what SARS must look at, must say, you saw tax coming down the line, and you did something to avoid it. So the first question must be, what is that tax that is anticipated? And we say in this case, the only way it could be applied would be if SARS were to say, you, Absa, anticipated paying tax on some amount, which you didn't, but the actual letter says the anticipation was by somebody else and not by Absa.
Why would it be unfair if the test was phrased in the following way and the question was asked, but for the tax avoidant nature of the scheme, the party would have had a tax liability?
Well, that is effectively, you can call it with respect to sort of a bootstraps argument, because that presupposes that there is a tax avoidance situation. You have to break it down.
Sorry to interrupt you. If objectively there's a tax avoidance scheme, what is unfair about the test being applied in that way?
Because you only know that it is objectively a tax avoidance scheme if you know what the alternative would have been. And the alternative you have to be able to identify. And it's not difficult with respect. SARS has done it for years.
And Section 80 doesn't require knowledge, is that right?
Section 80A, or?
Yes, doesn't require knowledge.
We contend that...
In this case, it doesn't require knowledge on Absa's part, part of a tax avoidance scheme.
We contend that you can only be party to a scheme or arrangement of which you have knowledge, or constructive knowledge.
But the legislature doesn't require that.
I beg your pardon, Justice Turan?
The Act doesn't require knowledge.
Well, the Act, we say, implicitly requires knowledge by requiring participation. And as I've said to Justice Matopo, participation involves volition, volition involves knowledge. It follows as night follows day in our submission.
Yes, I'm not sure I agree with that, but thank you, Mr. Yanis.
As you please.
Thank you, Mr. Yanis. Would you accept that as a starting point, one is dealing with the interpretation of a taxing statute and not a criminal a provision that creates criminal liability?
Certainly there's no criminal liability involved.
And therefore, to that extent, questions of knowledge and volition may be weighted differently, if I could call it that, in a scheme that really looks at cause and effect.
Yes, it's not one isn't in a situation of imposing a criminal standard, but the question is what, on a proper analysis of the taxing provision, the extraordinary taxing provision, what role does knowledge play?
Sure, and one could come to that, but would you accept as a general proposition that if an arrangement that is described as impermissible has certain consequences, that as a general proposition, and to some extent SARS speaks to the approach taken in Gallagher, that one looks at it objectively?
Subjectively. Gallagher was a subject.
Yes, but maybe I
SARS alleged the contrary, but the court didn't accept that.
And you don't agree with that one looks at the effect of the scheme? Because if that's the purpose of GAR, then one would look at the scheme, its effect, and dealing with its consequences.
No, we contend that the effect of the scheme is bound up in the tax benefit point and in the tainted elements. That's the objective. And then the purpose of the scheme is bound up in what the party entering into the scheme intended.
Mr. Janis, please help me, and I'm trying to understand this. So we're talking of what happened downstream, and it seems we can accept for now that Absa may not have known what was happening downstream.
Yes, as one must, yes.
Right. Had the D1 Trust not decided to actually leave the stream and go offshore to Brazil, what would have happened then? Let's assume that part of the operation did not materialize. I assume you would not have had an impermissible arrangement, correct? Because that was the tainted part.
Well, if there was no finding that D1 Trust avoided tax, then there would be no tax avoidance arrangement.
Sure. What would have happened then in terms of the scheme had it ended there? Because would SARS have received its income and its dividends tax-free, given what happened between
SARS?
Not SARS, Absa.
Absa. Yes.
What would have happened then?
Well, one can't know because the facts are not before us, but from a pure commercial perspective and contractual perspective, Absa was entitled to its dividends and was able to sue PSIC3 for its dividends, and it also had security arrangements with other entities. It would have been able to get its dividends. Its dividends would always have been untaxed because they were dividends. So irrespective of what happened down the track, from Absa's perspective, it was entitled to and would have been taxed as on the basis that it was only an entity that invested in preference share.
I asked this question because SARS had alleged that it was necessary for the D1 Trust to make the sort of investment in the Brazilian bonds to swap out, as it were, income that would have been taxable with income that would have been tax exempt. Would you agree with that?
Well, again, SARS alleges that is what happened. Whether it doesn't allege it was necessary or otherwise, I don't know if that language was used. But what it says,
well, I think it says it's implicit in that there was a swapping out.
Yes, what happened
cover.
Yes, what happened.
Income that would ordinarily have been taxable, not so.
So the point is that, and it's complex, but the point is that if the income that came from a direct loan to MSSA would be taxable, it's deductible in the hands of MSSA and taxable in the hands of the recipient, except because the recipient was the D1 Trust, was a foreign entity, it was not in fact taxed. It would not have in fact have been taxed on that. But the problem, as SARS has identified it, was that the D1 Trust needed to get the money to PSIC4. And if it had passed the money through to PSIC4 on a so-called conduit basis under the old Section 25, the old version of Section 25B, that tax exemption would have been lost in the hands of PSIC4.
Okay.
And so what it did was it took the income that it received, spent it again in buying a different form of income that didn't have that difficulty. So all of that is part of SARS's analysis, and we can't say anything about that because we weren't there and we don't know.
Sure.
But for present purposes, that's the allegation.
Sure.
Our argument is it's irrelevant because SARS says that was a tax benefit, tax avoidance. Maybe it is. For present purposes, we must accept it is. But it's not a tax avoidance that affects or touches Absa.
Sure, but that's not my question. My question is that if the effect of the swapping out was to insulate, as it were, that income for tax purposes, then what then happens is, as it went downstream, it now comes upstream back, correct?
Well,
and finally reaches Absa.
Well,
but with the protection that the swapping out afforded to it.
But Absa did not need any protection like that at all. It did not get protection from anything other than the fact that it invested in a preference share. So from Absa's perspective, its money was only ever going to be tax exempt.
Yes, that was Absa's intention.
And
if that money was put to different purposes and it had the effect of generating income that would have ordinarily been taxed.
But the point is then the analysis with respect to Justice Colopin is very important because you have to ask who's the person that the money is flowing to. So the person that did not pay tax that SARS says anticipated paying tax is the D1 Trust and PSIC 4. This loose with respect language that is used of somehow something is converted from one type of income to another type of income is dangerous, because monies are fungible and money flows pertaining in relation to a particular transaction. The source of money is irrelevant to the identification of the money when it comes to you. So Absa looks at it as dividends received from PSIC 3. Whatever happened to get that money into PSI 3's pocket cannot affect the fact that it comes to Absa as a dividend that is tax exempt. It was always that way and will always be that way. And that's why we say that any tax benefit is remote from Absa, and if SARS wants to attack it, it must attack the party that got the benefit.
So are you saying that if Absa made this investment with the intention of receiving these dividends, and ultimately that's what they received, the fact that it was received as a result of and was tainted by an arrangement of which they had no knowledge of insulates them from that?
We do say that, except we don't accept that the money coming to Absa could be said to be tainted in any way. It could be tainted in someone else's hands, but when it comes to Absa, it is just the money that Absa contracted for, no more and no less, in exactly the same.
And how that money was swapped out and converted wouldn't matter?
It doesn't matter unless SARS makes a case drawing Absa into that, but it doesn't do that.
Well, does SARS not say that once the swapping out occurred, then that income was tax exempt? Whether it was permissible or not is another matter. SARS finally says it wasn't permissible. It had the effect of providing that protection, and that protection then continued to endure upstream.
No, the protection was applied to PSIC 4 only. That protection did not apply at all to Absa. So the entity that got that protection was not the party that's before the court, and one simply cannot draw the entity that on SARS's own version did not get a tax benefit somehow into a GAR just because some other party did.
Okay, thank you.
Mr. Janish, just to clarify, if for any reason the transactions at the level of PSC4 and the D1 Trust had not taken place, Macquarie had decided not to do those things, or it had done those things but it had misunderstood their tax effects and it was taxed, am I right that as between Absa and PSC4, it simply had a right as a shareholder to the promised dividends?
PSIC 3, yes.
So PSC4 in 3 in that situation, assuming that it had misunderstood the tax consequences and tax had been paid further upstream, a Macquarie entity would have had to lend money to PSC3, or it would have had to get the money from somewhere. But either way, wherever the money came from, Absa had a right to its dividends.
That is so, and that's what the slightly complex security arrangements were there to achieve.
And if PSC4 for any reason didn't have the money, then there were these security arrangements.
That is precisely the case, Justice Rogers.
That's on that point. Just as the facetious aside, it may then be that Macquarie is the real party standing behind this because they'll pay the tax. If Absa pays the tax, then Macquarie will have to make good the shortfall.
That might be so, but with respect, that is not on the papers effectively.
Yes, thank you.
As the court pleases.
Mr. Shuttle Douglas, it's your turn.
Sorry, as the court pleases.
Just before you bet, the foreign note,
Yes.
well, when we started in the morning, I think it was probably 2 or 3 justices had seen your note. That includes myself. But we now have seen it all. I don't know what accommodation arrangements you've made with Mr. Janish, whether you've sent it to him, and how you propose to deal with that, Mr. Janish. Will you tell us when it's your turn to reply?
Deputy Chief Justice, what the position is that the state attorney who apparently instructs us,
Yes.
who is not here today, and for that we apologize, sent the supplementary note to Absa's attorneys at their previous firm. We accept it certainly never got to our learned friends. It simply records some of the foreign law. It would be unfair, given that the court has considered or had regard to our supplementary note, not to allow our learned friends the opportunity of responding. We would suggest, with great respect, that we leave the supplementary note as it is. It's before the court, and that our learned friends get the opportunity within such time as the court directs to make supplementary submissions on the foreign law. I've discussed that with my learned friend. He's in agreement with that process, and if it's convenient to the court, then we would propose that as a solution to the difficulty.
It's a sensible approach, I think. And you say Mr. Janish agrees?
Yes, he does.
Okay. So should we give you, 2 days for that, 3 days?
Mr. Yanis says 3 weeks.
I'm sorry, Deputy Chief Justice, it's very difficult to know without having seen the note how much time one will need. So could I perhaps ask for a week, or at least until the end of next week, to do that? And we'll do it as quickly as possible. Today being Tuesday, perhaps next Friday.
That's fine. Thank you. Thank you very much. Please go ahead, Mr. Sholto Douglas.
Thank you, Deputy Chief Justice and the court. In our heads of argument, at page 9, starting on paragraph 27, and relying substantially on the judgment of this court in the Section 105 judgment and on the letter of assessment, we set out what we understand and submit to be the impermissible avoidance arrangement that the court is dealing with in this matter, and relying particularly on the letter of assessment. On page 11, we deal with the purpose of the arrangements, which was to swap a taxable income stream paid by Macquarie, South Africa, the D1 Trust, for a tax-free income stream paid by the D1 Trust to PSIC 4, and then to PSIC 3, and then ultimately to Absa. And we say that but for that swap, PSIC 4 would have had to pay tax on the interest it received from the DI Trust, and that as a result of the swap, the interest received from the D1 Trust was tax-free, and that accordingly enhanced the dividend stream from PSIC 4 to PSIC 3, and ultimately to Absa. And that comes from a passage, in the letter of assessment, which is at page 385 of the record in volume 4. That is the letter of assessment, in fact, in relation to Absa. And in paragraph 78, really this summarizes the case on the issues that are relevant to this appeal. SARS says, viewed objectively, each Absa arrangement, you'll recall that there were 4 arrangements with Absa and United involved, and the total amount invested was 1.9 billion rand. Each of those arrangements was designed to channel the capital invested by Absa to Macquarie, South Africa, and the transactions undertaken by the D1 Trust were designed to shield from MSSA and the collateral instruments, there were a number of collateral instruments, guarantees and the like, from South African income tax by swapping the taxable income stream for the exempt Brazilian bond income stream, and in the case of Absa and United, a further conversion into local dividend income. The intervening entities were nothing more than conduits. In short, the effect of each arrangement was to increase the return from an underlying investment into an interest-bearing instruments, the MSSA notes or the collateral instruments, via the avoidance of South African tax. In other words, the objective purpose of each such arrangement was to obtain a tax benefit. While we in the letter of assessment, may I take the court to page 351. I've been taken to this page by our learned friends, paragraph 18, where Absa's understanding is recorded by SARS as being the arrangement consists of a back-to-back preference share investment into MSSA via PSIC3, which investment would be used to fund MSSA's broker operations. In 19.2, a guarantee and undertaking provided by Macquarie Group Limited to Absa. In all cases, PSC3 and MSSA were also party to such agreement, so this guarantee and undertaking, whereby Macquarie Group Limited guaranteed the preference share return and made certain undertakings regarding the tax treatment of the amounts involved, including gross-up provisions to maintain the level of preference share return should the amounts become taxable. So it was anticipated that there were amounts that might become taxable, and there was a gross-up arrangement, because Absa presumably would only enter into this arrangement with entities designated only by letters and numbers if there was a guarantee that it would get a return that would have to be enhanced by the fact that taxable interest income was converted to tax-exempt dividend income. Now, against that background, Absa contends the basis of the judgment in the 105 matter for the 2 errors of law. And with respect, this court carefully and narrowly circumscribed the matters that were to be dealt with in this hearing. And the first error of law, and it's relied on by Absa as such, occurred, they say, by SARS applying the GAR despite not having alleged that Absa itself received a tax benefit and that that tax benefit was achieved by the arrangement. It contends, and our learned friend made this clear in his oral address, that a tax benefit must refer to an anticipated tax liability that the assessed taxpayer, Absa, itself avoided, and that in this case any tax liability or any tax benefit was obtained by other entities, the D1 Trust and PSIC4. So their argument is essentially that for purposes of determining whether a taxpayer obtained a tax benefit, one inquires what tax would have been suffered had the arrangement not been entered into, and that if no tax was anticipated in the absence of an arrangement, then there can be no tax benefit. Now, with respect, there was a tax anticipated, and we'll come back to that. We've already dealt with the gross-up provisions. But our first response to that argument is that as a matter of law, an arrangement is an avoidance arrangement if the arrangement results in a tax benefit. And that's an issue taken up with my learned friend during his argument. And that law is in section 80A. Also, as a matter of law, the sole or main purpose inquiry is directed to the arrangement. And this is different from the old GAR, section 1031, which inquired what the taxpayer's purpose was. This is an objective test, or at least a more objective test. If one takes the taxpayer's ipse dixit into account, that is a factor to consider in the objective assessment of what the sole or main purpose of the inquiry of the arrangement might be. Section 80A unequivocally provides that an avoidance arrangement becomes an impermissible avoidance arrangement if the arrangement's sole or main purpose was to obtain a tax benefit, and obviously a tainted element was also present. But section, as Justice Majid put to our learned friends, section 80A does not state or even imply what party to an arrangement must obtain a tax benefit. It's the arrangement that must result in a tax benefit and then have as its sole or main purpose the obtaining of a tax benefit. Once there is an impermissible avoidance arrangement under 80A, SARS can then invoke its powers under 80B. And they are wide-ranging powers designed to fit a variety of circumstances. Neither of those provisions, 80A or 80B, say or imply that SARS may only apply the remedy to a specific or particular party or parties who obtained a direct tax benefit, which is ultimately what our learned friend's argument is. We submit that on a proper approach to the tax benefit inquiry, SARS did apply the remedy to the parties who obtained a tax benefit. The tax benefit was not the direct saving of tax in that particular entity. Instead, the tax benefit was passed on from the D1 Trust PSIC4 transaction to the party who paid the money, who funded the arrangement, and who received the financial benefit of the arrangement, Absa. And as we've submitted, that benefit, that return that was obtained, was enhanced by the fact that there was a tax benefit obtained by the arrangement, in the arrangement. Now, Absa seeks to restrict SARS to only applying the GAR to the parties who directly avoided the tax. But by design and careful design, these special purpose vehicles who were interposed in the arrangement are conduits. They have nothing left. The money comes in and it goes out. There's nothing there. So they say, with respect in argument, oh, we don't know if they were taxed. We don't know what their treatment was. There couldn't have been tax. There's no money there. In effect, what Absa argues, don't look at who gets the financial benefit of the tax, the financial advantage of the tax avoided. Look only at the SPVs. And sorry, there's nothing there, so move along. But even assuming what ought to be considered as the correct counterfactual in this case, which we say is not no transaction at all, but a transaction that is freed of the clothing that the structurers put on the arrangement. Absa directly saved tax in our submission. In order to analyze whether or not a tax benefit results from an arrangement, we submit that the correct but-for test is not to consider no transaction at all. And if that were the correct approach, then with respect, most tax avoidant transactions would escape the reach of the GAR, because one would say, well, if I wasn't going to get a tax benefit out of this transaction, I wouldn't have entered into it. And therefore, there's no tax benefit. The correct approach is to consider the probable or appropriate counterfactual. And that, we say, is to consider the arrangement stripped of the elements that make it a facade behind which the creation of a tax benefit can be established. The purpose of the arrangement was to obtain a tax benefit, whether or not the tax benefit accrued to Absa, and even if it accrued to the D1 Trust or PSIC4. If the transaction had not been dressed up with features designed to avoid the imposition of tax, the taxpayer would have incurred a tax liability. On SARS's assessment, on SARS's application of ATB, Absa's investment would have generated taxable interest income had it not been for the tax avoidant features of the arrangement. It would have been, in effect, a loan. By participating in a scheme that avoided the generation of taxable interest, Absa directly obtained a tax benefit. Our learned friends have relied on some of the older cases. One that was discussed was Gallagher. Gallagher dealt with Section 103(1) of the Income Tax Act, which was repealed when the new GAR was introduced. As I've said, its test was substantially different. It postulated a subjective test by the taxpayer sought to be subjected to the GAR, and with respect, one has regard to those cases with a certain level of caution. The tax benefit inquiry under the new GAR depends ultimately on what the Commissioner reasonably determines would have been done with Absa's investment absent the tax avoidant features of the transaction. In this case, SARS has said what would have been done was Absa would have earned interest and not the return free of tax in the form of dividends. That is, of course, a factual inquiry, goes beyond the questions before this court, and it's, with respect, not an appropriate question to be resolved by way of an exception type review, certainly not on the facts of this case. Of course, the exception analogy dealt with in the 105 judgment suits the case to a point, but it can only be taken so far in our respectful submission, because a letter of assessment is not a pleading, and the consequences of a successful exception are not available to SARS when they have assessed a taxpayer, and Section 99(1) of the Tax Administration may prevent them from ever revising that assessment in due course. So up to a point, with great respect, it works, but we're not in a trial situation yet, and we're not anticipating evidence at this stage. Also, as the judgment in the 105 appeal determined, a failure to raise an argument in a letter of assessment is not fatal in the sense that it precludes the raising of an issue in a Rule 31 statement. That was dealt with in paragraphs 17 and 18 of the previous judgment. And in our submission, it wouldn't offend the provisions of Rule 31(3) if SARS were to allege actual knowledge on the part of Absa, nor would it constitute a novation of the whole of the basis of the assessment. But that would be for another court to determine on another day. We submit, for the purposes of this hearing, the important issue is that the letter of assessment isn't a final pleading. It is what it is, and we understand with great respect that the exception analogy, but it does have important distinctions which we believe we have highlighted. Absa describes SARS's case as being that any financial or economic benefit suffices to qualify a party to the arrangement. In other words, you are a party to the arrangement if you get any financial or economic benefit. We submit that's an incorrect formulation of SARS's case. SARS explained at paragraph 88.2 of the letter of assessment that Absa is a party to each Absa arrangement by virtue of its funding thereof and its economic participation in the returns from such arrangements, including the tax benefits. In other words, SARS alleged that Absa not only received an economic benefit from the arrangements, but it also funded the arrangements and received substantially all of the tax benefit that the arrangements generated. Now, a learned friend had something to say about that aspect of SARS's case, but it did. It received substantially all of the tax benefits that the arrangements generated because through a series of conduits, the tax benefit was passed upstream to Absa. So the upshot is that Absa received an inflated return on its investment for no reason other than its funds had been used in an impermissible avoidance arrangement. And that statement of an inflated return was made in the letter of assessment at one of the passages that I have referred to. Just bear with me. Yes, it's in that paragraph 78 of the letter of assessment. Bear with me. Absa would, on its version, be entitled to avoid tax liability even if it consciously and deliberately remained ignorant of the inner workings of the various tax avoidance steps in the arrangements. And as our learned friend pointed out, our law does turn its face against avoiding liability on the premise of a willful ignorance and other such descriptive features. It may be that one factually has no knowledge, but if one has assiduously worked to avoid having knowledge in order to avoid the tax consequences that would follow from such knowledge, then our law would not recognize the absence of knowledge as being genuine and honest. Justice Mhlantla asked whether this case, if decided in favor of Absa, would create a blueprint for claiming ignorance in these complicated schemes that are constructed for the very purpose of avoiding tax. And my learned friend said no, but with great respect, of course it would. If this court says, you, the taxpayer to whom the GAR is being applied, must have actual knowledge, then the purveyors of these schemes would say to their clients, I cannot tell you how this works. I will give you a guarantee backed by First Rand Bank Limited or Standard Bank that you will get your money. And I will give you a guarantee that if you have to pay tax, we will pay it for you. But I'm not going to tell you, because if I tell you, then you will have the requisite knowledge to allow SARS to tax you under the GAR. And that, with respect, is an impractical outcome that cannot be interpreted to accord with the purpose and meaning of the section. We submit that an arrangement does not require a consensus or a meeting of minds of any number of persons, 2 or more persons. A taxpayer could be party to an arrangement even if they are not aware of all of its details, and that, with respect, we submit must be so. Of course, ultimately, what SARS does must be reasonable, and the question was raised whether whether the GAR could have been applied had one of the conduits been assessed to taxes. With respect, it doesn't arise because the conduits, there's no purpose in assessing them to tax. They only received the benefit or created the benefit in order to pass it on. Then finally, on the question of costs, this is dealt with in paragraph 323 of the section 105 judgment. We say 323 on page 129 of the judgment. The court there dealt with the fact that one of the disadvantages to hearing a review, in other words, granting 105 relief, is that SARS is no longer able to assert its entitlement not to pay costs under Section 134 of the Tax Administration Act. It is deprived of that protection, and the court effectively, well, the court said SARS should not likely be deprived of the cost protection it enjoys in the tax court. And with respect, we say there should be no costs if Absa is successful, and with great respect, New Africa was a matter that considered the constitutionality of legislation. We do say that that substantially distinguishes the matter from a matter where pure financial interests are pursued. And in any event, the court has a discretion as to whether or not to apply BioWatch in a particular case, and we say of all cases, this is not the case in which to apply BioWatch. So we would submit ultimately that the appeal should fail and that we make the rather modest claim to the cost of 2 counsel in that regard. Those are our submissions.
Thank you very much, Mr. Shorter Douglas.
Shorter Douglas, I raised this with Mr. Janisch, but there's also another counter argument that if one interprets the section, the GAR provisions in this case, in the manner that you propose, is there not a danger that almost leads to SARS, giving SARS a sledgehammer to willy-nilly impose tax liability on parties who genuinely have no idea of what's going on downstream, who bona fide invests, expecting a return on investment, and then doesn't know what's going on? How is that counted?
It would apply equally. In other words, with respect, this case is being determined on the basis that Absa genuinely didn't know. Now, if one accepts, or at least on one leg that's the position, then SARS persists in saying that where there is an impermissible avoidance arrangement, which is a matter of certainly principally objective determination under Section 80A, then under 80B, SARS can do what it is entitled to do under that section, whether that person knew or not. And with respect, one may describe it as a sledgehammer, but all it's actually doing is making sure that the fiscus gets what's due to it. It's SARS performing its constitutional function of collecting tax in accordance with the legislation and without discriminating between different types of taxpayers. So in other words, once that tax benefit is shown to exist, SARS has the power, which it must obviously exercise reasonably under Section 80B, to correct the fact that money that should have gone to the fiscus is now, in this case, going to Absa.
Janisch drew our attention to Section 80G.
Yes.
When it comes to the question of the tax benefit and this presumption of purpose, and he emphasized that this section speaks of a party, and he says that fortifies his, or Absa's interpretation of these relevant GAR provisions. What do you say about Section 80G?
Well, Section 80G is a deeming provision, or it creates a reverse onus. But where it speaks, and I believe, just bear with me a moment, if I just find the reference to the law. What our learned friend's argument relates to in 80G is that an avoidance arrangement is presumed to have been entered into or carried out for the sole or main purpose of obtaining a tax benefit unless and until the party obtaining a tax benefit proves that reasonably considered in the light of the relevant facts and circumstances, obtaining a tax benefit was not the main purpose of the avoidance arrangement. One must see where this comes into the scheme of the GAR. What's clearly, this is a litigation presumption. This is a presumption that says either at an earlier stage, but certainly at the time that the trial, the appeal takes place in the tax court, the taxpayer, in other words, the party determined by SARS under the GAR to be the party against whom, or in respect of whom, it is going to exercise Section 80B powers. That is the party that's being referred to in ATG. In other words, it's now an already identified party. SARS has identified the impermissible arrangement, and now we're dealing with what the purpose, was it sole or main purpose of the arrangement to avoid tax. And the person who has already been identified must now deal with the onus that's cast on them under Section 80G. So with respect, we don't understand Section 80G to assist Absa's argument.
I was looking at a note here on the computer when you argued about the analogy exception, the exception analogy. Can you just repeat that for me? I'm sorry to have you do this.
No, not at all.
I missed, I think, the important parts of it.
Not at all. So what the Section 105 judgment does is to say, by analogy, one looks at the assessment and says, applies certain principles that relate to an exception to that. For example, that you've got to give, allow for every reasonable meaning to be given to documents and so on and so forth. And that if you do not make an essential element, in other words, that if your particulars of claim lacked an essential element, then by the same token, if your assessment lacked an essential element, one could, as it were, dismiss the case on exception. And we, with great respect, understand and have no difficulty with looking at it in the way of an exception up to a point. But one must be appreciative of the distinctions between a notice of assessment and a pleading. And a pleading you can amend, you can apply to court, you can do, you know, there's no question of prescription in the ordinary course unless you're introducing an entirely new claim. But then under the Tax Administration Act, if you are novating the claim, you can't do that either. So this court explained that Rule 31.3 and the corresponding Rule 32.3 doesn't prevent new assertions being made in a Rule 31 statement. So, for example, amending a Rule 31 statement after discovery is permissible so long as it doesn't cross the threshold of novating the entire factual and legal basis or requiring the issue of a new assessment. So that's a fairly wide scope in our submission for making amendments. And this court referred in that regard to Rule 36, which supports that construction because Rule 36 deals with subsequent discovery and says after discovery, after an amendment to a Rule 31 statement, for example, the other party can request further discovery relating to the new allegations made. So that's dealt with, as I say, I think in 17 and 18 of this court's previous judgment.
And so, just finally, if we are with SARS here, what happens to the matter now if we find for you?
Well, the review...
It has to go back, isn't it?
Yeah, the review will fail,
yes,
and it will go back to the tax court where in effect it already is.
Yes.
Thank you.
Mr. Schulte-Douglas, in answer to a question from my brother Majid concerning Section 80G, you said we must see where it fits in. It's a litigation presumption. Perhaps it might also arise earlier. And you said this should be the phrase should be understood as referring to the party that SARS has already identified under Section 80B as the party whom it intends assessing. I fear that submission may be circular, because one of the questions is, can SARS tax a particular person under Section 80B if they didn't receive the tax benefit? Assuming for the moment, I know you have arguments on this, but assuming that Absa itself did not receive the tax benefit, didn't avoid an anticipated tax liability. The argument is that in understanding what the powers of the Commissioner are under Section 80B, the provisions of Section 80G are part of the relevant material. And that envisages that the party assessed will be the party who obtained the tax benefit. And that party must be the counterparty in the tax court. You can't have an outsider bearing an onus of proof.
Absolutely.
So do you say, in fact, we must, the phrase, until the party obtaining a tax benefit has proved X, Y, or Z, you say we must read that as the person whom SARS has chosen to assess under Section 80B, even if they didn't receive a tax benefit?
Yes. And with respect, because it can fail on either ground, it is circular in a sense, and with respect, I understand that. But when one looks at ATG and one looks at the onus that is cast on somebody, the person upon whom that onus is cast is the person who is subject to the GAR, who SARS has decided to apply the provisions of ATB to.
The question is what SARS powers are under GAR to assess, who it can assess. One must obviously not say, well, I've now interpreted Section 80B in a vacuum. I have decided what it means, and therefore Section 80G has to be twisted to accommodate it.
No.
One must interpret the GAR provisions as a whole. And does your submission boil down in respect of Section 80G to say that we must not understand the phrase until the party obtaining a tax benefit? We must not understand that literally.
No, the presumption would not apply against a party that did not receive a tax benefit. So it can't be, which is also relatively circular. But yes, as you put it, Justice Rogers, that would be understandable.
I have to say that in Absa's case, if it has to go to the tax court on the merits and it didn't get the tax benefit, you can't invoke the presumption. I'm not
Clearly
sure
not.
That submission.
No.
All right. So we must modify the language in line with your broader interpretation of the GAR provisions.
We would submit so. We would submit, yes, we would submit that on a proper interpretation of ATG, it can only apply to the person who has been selected for the application of the GAR.
On the question of costs, you referred to the passage in the 105 judgment which refers to the fact that if you go to the High Court, SARS and the taxpayer both are deprived of the usual protection they have against costs in tax court litigation. That is, of course, true in respect of the court of first instance. So where the High Court is asked to take the place of the tax court to resolve a tax dispute, there might be a strong reason not to award costs unless somebody has been unreasonable. But it's always been the practice in my experience that in further appeals, tax appeals from the High Court to the SCA, and in this instance to this court, costs are usually follow the result. In other words, that consideration doesn't apply to further appellate proceedings.
Absolutely understand with respect, Justice Rogers, and we won't press that issue any further.
And then finally, you have made the point about the fact that the grounds of assessment under Rule 31 may not look exactly like the letter of assessment, and there may be a further dimension placed on it. And as you say, we are not concerned in this case as to what the outer limits are of what you can and can't do when it comes to a Rule 31 statement. Is your concern that, suppose we find that in order to be a party to a scheme, Absa needed to know about the elements higher up of which it claims not to have been aware. And if we say SARS, without conceding that Absa doesn't have the knowledge, is willing to run the case saying that the knowledge is irrelevant, it doesn't matter whether it had knowledge or not. If we say that that is wrong, SARS's view on that is wrong, do you say we must nevertheless bear in mind that you might overcome that deficiency when pleading your Rule 31 statement?
We do say that, Justice Rogers, because, and that's really the distinction that we sought to draw between the exception type proceedings and these. One appreciates that the assessment and the position adopted by SARS may not be the final word on it.
I don't recall exactly what I wrote when I wrote it, but in the 105 judgment, I think one of the points made, I think it was in the context of this case, perhaps other cases, that SARS hasn't said, and I meant on affidavit, that it intends altering the basis of its assessment. So we don't have before us a case where SARS says, I intend saving this assessment by pleading actual knowledge. And it's quite possible on the investigations that SARS has done that it feels it couldn't properly make that allegation. So I wouldn't want what we can practically do with the case to be kneecapped by theoretical possibilities that don't represent the real world. Are you asking us to take into account that SARS realistically may plead actual knowledge?
I cannot make the submission any stronger than this. There is a process yet to be followed in the tax court, if we go back to the tax court, which would include discovery, would include oral evidence, and would include cross-examination. If in the course of, say, discovery, it becomes apparent that Absa was aware of every step along the way, then we would be entitled to amend our Rule 31 statement to allege actual knowledge. And we would not, to use the kneecap reference, we would not wish this court to kneecap the possibility of a successful opposition to a tax appeal because we have a curtain in front of us which is yet to be opened. It may reveal nothing. I accept that.
Well, that's really like saying, if we compare it to high court proceedings, I don't have because of course you won't have discovery before you make the Rule 31 statement. So in that respect, you won't have more information than you have now.
No.
And as you know, one can't go to court and say, well, I don't have a cause of action, I can't plead it, but just allow there to be discovery and I might be able to put it right. You can't do that.
You definitely can't. I appreciate that, and with respect, Justice Rogers, you dealt with that very point in the 105 judgment, on the basis that you can't make an allegation in particulars of claim that are unsupported by facts.
Or you can't say, I don't know this yet.
I don't know this yet, but I may know it, yes. Yes.
I'd like to ask you, and perhaps Mr. Janish could also mull over it when he comes to his reply, is there a way, because I don't think, we haven't been addressed on, and I don't think it would be right for us to decide what, for example, that you can now plead actual knowledge in a Rule 31 statement. Mr. Janish may say you can't, and that's not really an issue before us. Is it possible to preserve the positions of the parties, competing positions of the parties, by exercising our powers under Section 172, because the High Court is hearing a review? I can't remember if it said it was a Padger review or some other sort of review, but either way, ultimately you go back to a just and equitable remedy. Could the court, instead of setting aside the assessment, make a declaratory order that SARS can't hold Absa liable in the absence of alleging knowledge of all the steps in the scheme? Because if you are then able to issue a revised letter of assessment or issue a 31 statement, which then makes an allegation of actual knowledge, Absa's rights will be preserved to say you can't do that. So would potentially a declaratory order in place of a setting aside meet the case?
With respect, yes, Justice Rogers. I would have thought so. Principally, it allows the parties to continue along the path they are currently embarked on, absent the one issue that's removed by the declaratory order.
Because I think I also said in relation to the this court said in relation to the Absa case in the 105 judgment that although it's a review based on error of law, it would ultimately, it would in practical effect be a declaratory order on the two legal questions raised.
Right. Yes. That is of course.
Alive to the concern of not necessarily closing avenues, which may be open to SARS.
Of course, we would invite the court to dismiss
I appreciate
the review on the
first prize.
on the basis that the actual knowledge isn't necessary. Yes.
Thank you.
Thank you.
Can I just follow up on that point?
Yes, Justice Mandrobo.
If you are successful, do you need the declaratory order or not?
If we're successful on the main argument, we don't.
Yeah.
But if we are unsuccessful on the main argument, then in our submission, a declaratory order would allow for issues, or at least potential issues, to be ventilated in the tax court, which a upholding of the review application would not allow. So we would prefer to losing outright to get a declaratory order.
Yeah, sorry. I'm not following very clearly. So you would prefer a declaratory order?
No, we would prefer
Yeah.
that the review application be dismissed
Yes, that's
outright
the first
on the
prize.
basis that one doesn't need actual knowledge of all of the steps in an arrangement in order to be a party to that arrangement.
Now, for us to get to the point where we are to exercise our rights in terms of Section 172 and say, you get a declaratory order, what is it that we need to say to arrive at that conclusion?
You would, with respect, have to find against us on our principal argument. You would have to say that you can't apply the GAR to a party who doesn't know of every step in the arrangement or didn't itself receive the tax benefit. But there's avenue for an expanded or altered case in the tax court, so we'd like we'll allow you to go there. It's a second prize with respect.
Does it mean that even if you succeed on the first part, Absa at the tax court would be precluded from relying on the lack of knowledge or otherwise?
It would, with respect, be allowed to rely on the lack of knowledge.
So basically, the two orders that are postulated doesn't help.
But the second order, as I understand it, would operate in the event that the court wasn't with us on our principal argument. That's how I understand it.
But what comes out in the wash is, at the end of the day, before the tax court, Absa would be able to assert its case that it had no knowledge.
Yes, because that would not be raised judicata as far as I understand.
That is where I just wanted to find out whether it can be hit by res judicata.
Yes.
Okay. Thank you.
I need to find clarity on this last angle that's now been pursued about the declaratory order as opposed to the dismissal of the review on appeal if we do find for you. So what I want to know is this, you say that first prize would be for you to, obviously, if we uphold your argument, would be that we dismiss the appeal against, that the appeal be upheld against the dismissal of the review by Sutherland DJP, right?
It's that the appeal against the SCA judgment would be dismissed.
Well, the SCA judgment didn't delve into the merits, did they?
No, they didn't. But that's why Absa's before this court. They are here as appellants against the SCA judgment.
Yeah.
They're not here as respondents in the Sutherland judgment.
Strictly speaking, we are looking at just from a practical point of view, we are looking at the High Court's judgment. Because they dealt with the merits of what we're dealing with now. In the earlier judgment of this court, which my brother Rogers J. wrote, the unanimous judgment, we only dealt with the SCA's part of the case, and there the leave to appeal was granted and the appeal was upheld.
Yes.
But now we're dealing with the substantive issues, which are these two errors of law, which the parties have argued, and that specifically deals with the High Court judgment, isn't it, sir?
That is so.
Yes. Now, I'm trying to just clarify for myself where the case would go if it goes back to the tax court, just under proceedings. If you do succeed in your main argument, then what happens next in the tax court? There'll be a change of pleadings, isn't it?
Exchange of pleadings? Absolutely.
All right, I'll leave it there for now. Thank you, DCJ.
Thank you.
Mr. Sholto, Douglas, I just wanted to take you back to the issue of the tax benefit. As I understand it, and correct me if I'm wrong, your argument is essentially that Absa's received a tax benefit because it would have earned interest had in other circumstances, and that it decided to invest in this preference share scheme, which was part of a GAR kind of an authorized scheme. It would have otherwise earned interest on the funds.
So, Justice Savage, perhaps to refine that, SARS contends in the letter of assessment and elsewhere that Absa received an enhanced return on its investment because it had the benefit of the tax swap from taxable income to tax-exempt dividend income in the arrangement.
But you accepted in a normal preference share arrangement it would have dividend.
Absolutely.
Which was not taxable.
Absolutely. Now, the interest comes in because SARS, under its powers in terms of ATB, has determined that the correct remedy to apply under the GAR is to treat what is tax-exempt dividend income as taxable interest income. And it has the power to do so under Section 80B. So it's a bit of a shortcut to say, as I shamefully admit I said, that that the benefit is, instead of receiving income, they receive dividends. They received an enhanced return because of the tax wheeze. The consequence is that SARS invoked its powers under ATB to treat that return of dividends on preference shares as taxable interest.
But you do accept that if it had chosen to invest in another preference share scheme, that it would have been, it wouldn't have received a tax benefit. The fact of the matter is that preference shares are treated in the way that dividends in respect of preference shares are treated as they are.
Absolutely, Justice Savage. Put differently, if it hadn't been for the D1 Trust and PSIC4 doing what they did, this transaction would not have been subject to the GAR.
Now, it's interesting that SARS, there was an amendment to the Act proposed in respect of such dividends, but that seems to have been withdrawn.
It has been withdrawn, yes.
The other issue that I'd like to just canvass with you is that of the presumption, because it seems to me that, as I understand you, as far as the tax benefit is concerned, you would like to see an interpretation of that provision to allow SARS to really expand its notion, and provided well, let me put it this way, provided it's acted reasonably, that even if it can't show on the facts that there is a tax benefit, that just provided it has acted reasonably, that it can allege a tax benefit, and that's sufficient for allowing it to proceed against a taxpayer.
Well, it gets to a point where it has established an impermissible avoidance arrangement and the tainted element that is required, where the tax benefit is presumed by ATG. So it doesn't have to make an allegation of a tax benefit where there is none. It can rely on the presumption in ATG, and then the taxpayer must rebut that presumption. As I said, whether it does so in its response to the assessment or at a later stage of the proceedings, it has that, SARS has the presumption and the taxpayer has the right to rebut the presumption.
What sort of limitations would exist, apart from a reasonableness limitation that you...
Well, there's no limitation.
I mean,
The reason,
SARS, this could presumably be used quite in quite a negative way, potentially, if it was left unchecked. You know, the allegation made that there's this tax benefit.
no, well, that's, the allegation that there's a tax benefit is insufficient to invoke the GAR. There are a number of other hoops that SARS must jump through before the presumption arises. So there's an inherent check on how the GAR is invoked. The only aspect that ATG deals with is the presumption effectively of purpose. So the sole or main purpose of the transaction was to obtain a tax benefit. That is it. So once it's shown that there is a tax benefit, that there is a party, that there is an arrangement, that the arrangement is an impermissible arrangement, a presumption arises that the purpose of the arrangement was to obtain the tax benefit. So it's not as if SARS can simply say, okay, today I'm going to decide that you've received a tax benefit. It has to emerge from the other inquiries having been satisfied first.
And what if a party is party to a scheme such as this, an arrangement such as this, where in this case Absa says, well, we know nothing of a GAR arrangement, but we in good faith engaged in, invested in a preference share arrangement, and that we are not party to the GAR. What kind of protections are there for such a party? On your version, on your say-so, one would run the whole process and they'd have to go through the tax court and so on and so on. They couldn't bring this type of a proceeding.
No, they couldn't with respect. The idea that the purpose, motive, intention of the taxpayer determines liability for tax is with respect foreign to tax law. Mm-hmm. It's all about the facts and what happened. Was there a tax benefit? Were you a party to an arrangement where there was a tax benefit? Was the sole or main purpose of the arrangement a tax benefit? If all of those are satisfied, then there's a presumption that your purpose was to obtain a tax benefit. Then SARS can invoke its powers or apply its remedies.
How does one protect against a situation where that party who in fact is an innocent party, is wrongly accused?
The question is whether or not the money that party got, innocent or guilty, was money destined for the fiscus or genuinely destined for that party, is determined without having regard to questions such as guilt and innocence.
But you understand what I'm saying. Somebody who says that they had no knowledge that this was a GAR type arrangement and that they invested in good faith in it. You're saying that they can't bring in these kinds of proceedings. They must run their case.
They must run their case. And if they show on the evidence, and if they rebut their presumption, and if they show that there is no, that there was nothing about the scheme or arrangement that gave an indication that there was any kind of tax benefit. So, for example, there wasn't a gross-up provision in an agreement that says if you have to pay tax as a result of this arrangement, we'll pay it for you. Then, at the end of that process, the court may very well say, sorry, you've established that your sole or main purpose was not to obtain a tax benefit, it was to achieve a commercial purpose, and the GAR doesn't apply.
And then what costs at that level?
I beg your pardon?
What of costs at that level? You know, when you ran it through the tax court?
Unless SARS has acted unreasonably or the taxpayer has acted unreasonably, there are no costs in the tax court.
That's correct. That's why I ask you. So there would be no costs?
Yes.
Thank you.
Thank you, Justice Savage.
Mr. Shelter Douglas, according to SARS, an investor need not have knowledge of the tax avoidant nature of an arrangement to be considered a party. And that party receives a tax benefit if it receives a financial benefit from what has been classified as an avoidant arrangement. Now, how do we distinguish the present case from a scenario where an ordinary investor buys shares in a company innocently, and that company subsequently organizes a scheme to avoid tax? Would such ordinary investor be liable under GAR?
No, in short. And the reason for that is that the sole or main purpose test would fail. In other words, the investor would come to the tax court and say, I was saving for my retirement, I was offered an investment, its returns were market related, whatever. My sole or main purpose was something other than obtaining a tax benefit, and the GAR couldn't apply.
Well, why would that be different if Absa comes and says the same thing? Why should it be different?
Because of the nature of the arrangement as we know it now. In other words, as disclosed by Absa, with all of the conduits, the special purpose vehicles, the back-to-back guarantees, the guarantees of tax growth hubs, and all those sorts of things.
All of that. Why should an ordinary investor be treated differently from a company like Absa?
No.
And they participate in the same arrangement, and they both lack knowledge.
If there's no reason to treat one taxpayer differently from another taxpayer on the same facts. Absolutely not. But where it gets decided on the issue that's being raised with me now is what the sole or main purpose of the arrangement was. And if the sole or main purpose of the arrangement entered into by a taxpayer is not to earn a tax benefit, it's some other purpose, then the sole or main purpose of the arrangement will not meet the requirements of the GAR. If, however, unbeknown to that taxpayer, there is a tax scheme involved where a tax benefit is worked for and obtained by a variety of different entities, conduits within that, then with respect, the same would apply to that party as would apply to Absa. In other words, one looks at the arrangement, one determines what the sole or main purpose of the arrangement is, and one decides whether or not a tax benefit was obtained by a party to that arrangement, and one looks at who got the benefit, and one determines the application of the GAR on that basis.
Is that not an unfair system?
There's a case, and I've forgotten what it is. It says there's nothing fair about tax. The point is,
that
Justice,
sounds like what I say to my children.
Yeah, no.
That life is not fair. No. Used to it.
The point, Justice Straughn, is really the GAR is aimed at, while permitting tax avoidance, circumscribing the boundaries beyond which you cannot go, and then saying if there's money that should have gone to the fiscus and it's gone to someone else, then they must disgorge it for the benefit of the fiscus.
If knowledge is not required for an investor to be considered a party under GAR, would this not chill investment in South Africa given the fears of unforeseeable tax liability in the future?
It may put investors on notice to look for these things, to understand what they're doing when they invest in complex schemes. But with respect, the opposite is also true that if one allows a claim of lack of knowledge to defeat the application of the GAR, that would have the effect of depriving the fiscus of money that was due to it.
Why can't we accept what Absa says as to their understanding of the scheme? That they invested in PSIC3 and that after the money went to MSSA and that's all.
We can accept what is said on these papers at this stage, which include a little more than that and includes the knowledge of the conclusion of agreements with backing parties and with gross up of tax and so forth. That's in the notice of assessment. So one can and must accept what we know on these papers. One cannot assume that they know more than what is disclosed in these papers.
And why shouldn't they be successful based on what they say and what they claim to know?
Because they received a tax benefit at the end of the day. Because they received an enhanced return, the enhancement being the proceeds of the tax benefit created by the D1 Trust PSIC4 transaction and sent down or sent up to them through conduits. They received the tax benefit. They funded it by putting 1.9 billion rand into a company designated by letters and numbers, and they received a return which was greater than that had the arrangement not involved a tax-driven transaction aimed at passing the benefits of that to them, to Absa.
Thank you, Mr. Shelter Douglas.
Thank you, Justice.
Justice.
Thank you, Mr. Shelter Douglas. Thank you.
Thank you, Deputy Chief Justice.
Mr. Yanish, I think you have 10 minutes.
As the court pleases. The first point I want to make, excuse me, is that the idea of an enhanced dividend stream or an amount that was more than would otherwise have been obtained, my learned friend took the court to page 385 to a paragraph 78, and I invite the court to, in its own time, to look at that paragraph again to see that, in fact, what is alleged here in terms of increasing returns is only alleged vis-à-vis the D1 Trust and MSSA. In other words, it is the suggestion of enhancement does not apply to Absa. And it's important that you will find nowhere, as I've said, a suggestion that Absa itself expected 10 Rand and got 15 Rand because of something else that happened in the transaction. In fact, as Justice Rogers pointed out, it was going to get its amount anyway, simply because of the fact that it contracted for it. And so one must decide this matter with reference to the core fact, as we stated in the outset, that there is no question of an enhancement of an additional amount that Absa gets. Absa simply gets what it contracted for. The fact that Absa made provision for a gross-up, etc., is explained, as Justice Rogers pointed out in the Section 105 judgment, by the fact that there is this provision, Section 8, capital EA, which I referred to, which has the effect of, in the case of so-called third-party backed instruments, of ensuring that what it would ordinarily be an exempt return becomes a taxable return if certain qualifying circumstances are not actually met at other parts of the transaction. And so obviously, Absa sitting in its position saying to Macquarie, you'd better make sure that in fact it is a qualifying position. If it's not, I'm going to pay tax for no fault of my own, you're going to gross it up. The fact that that provision is there says nothing about some sort of suspicion that there was something going on behind the scenes It's a pure provision based upon Section 8EA. Now, but just in relation to the language that's been used in our learned friends' submissions and some of the questions, we submit that you can't say that someone can pass on a tax benefit or that Absa can receive a tax benefit when it doesn't have an anticipated tax liability. A tax benefit is something by definition which applies only between a taxpayer and SARS. And so in this particular case, the tax benefit lies in the fact that the D1 trust didn't pay tax to SARS. The fact that Absa received a different amount in a different circumstance doesn't mean that Absa received a tax benefit. One has to be precise about language, and statutory language in particular. And without the anticipation of liability, there can be no tax benefit, however Absa benefited financially. Our learned friend dealt with the question of the proper counterfactual. So he accepted that you need to be able to demonstrate that there has been a tax benefit by reference to what would otherwise have happened. And he talked about the proper or appropriate counterfactual. Now, we agree with that in principle. So we look at the letter of assessment to see what is the counterfactual on which SARS bases this assessment. And the answer is it has no counterfactual vis-à-vis Absa. It does not say that Absa would have invested in anything else. In fact, it's quite possible that if Absa knew it could not invest in a preference share, it would never have raised the money in the first place to do it. So in other words, there is simply no averment that apart from this scheme, Absa would have done something commercially different that would have exposed it to a tax liability. That doesn't mean SARS wouldn't be able to allege it, but clearly it's unable to allege it. And in that regard, if one then gets to the question of the entity that then has to deal with the presumption, one can't say that the presumption applies until such time as you know that there has been an avoidant arrangement. So it's circular for my learned friend to suggest that we'll just look at what SARS says the remedy would be, which is to assume that the money that came in as dividend actually came in as interest, and from that create the counterfactual that there would otherwise have been interest. You have to do it in sequence, and you have to finish your analysis on what is an impermissible avoidance arrangement before you can decide what the remedy is going to be. The cart cannot be put before the horse. I want to just dedicate the rest of my reply to the issue, the debate pertaining to what happens to this matter in the event of success or failure. And obviously, to the extent that the court is against Absa, the review is refused, then one goes off to the tax court. But that's not the focus of the questions. The questions that came, I think, started off with Justice Rogers, were to the effect that what happens if the court is with Absa? What does it do? Does it set aside or does it not set aside? Now, it sounded to us a little bit with that as if we were redebating the Section 105 point. That is water under the bridge. This is a review application. It is a review of an exercise of public power in the form of the assessment. The court has accepted that in its judgment. That was the basis of Sutherland's judgment as well. So what we're dealing with is an appeal against an SCA judgment that set aside what Sutherland himself did, Justice Sutherland himself did, which was to set aside the assessments in their entirety. And if we're successful in our appeal, the logical consequence is that that is what happens. The assessments are set aside. The only circumstance, and the point of Section 105, and why we asked for the approval, I beg your pardon, the determination, was because we wanted to get finality in this transaction and in this dispute. We wanted to make sure that the court would say, I'm sorry, SARS, but if that's all you've got, it's not good enough, and because that's all you're relying upon, that's where you must stand and fall. We're not precluded from bringing a review. In fact, we are now allowed to bring a review. And because we are bringing a review against the exercise of public power, if the court finds that that's unlawful, the proper approach is to set it aside. The only circumstance which our learned friend suggested might happen is that something else might come up in the course of ongoing litigation, such that one could potentially amend. We aren't in tax court litigation. We're in high court review litigation. If we succeed, we succeed. But as paragraph 318 of the Section 105 judgment said, SARS has had ample opportunity to say that it intends to depart from the grounds of assessment stated in the letters of assessment. And my learned friend was asked the question, are you seriously saying that you could be averring that Absa did have knowledge? And my learned friend, of course, couldn't say that because those are not his instructions, and they cannot be his instructions. So all we would say is that if there were some realistic possibility of another case being presented, perhaps this court might consider things differently. But on the facts before the court, the case reaches its high water mark on what you see in front of you in the letter of assessment. And the proper approach would be to bring this particular dispute to finality without making the parties jump through further hoops, which would effectively mean that the Section 105 exercise that we all went through at great expense ultimately would be fruitless. So on that basis, we submit that the appeal should be upheld, and the proper result will be to set aside to confirm the judgment of Sutherland ADJP, which set aside the assessments on review. Thank you, Deputy Chief Justice.
On this last part, when you drafted your initial application for leave to appeal in this court, I'm looking at volume 7, page 535. You said that if leave to appeal is granted, you would ask for an order in paragraph 4 of page 535 that the SA order be set aside, and substituting it with an order that the appeal against those orders, paragraphs 1, 4, and 5 of Sutherland ADJP, be dismissed with costs. So in effect, you're asking that the appeal against the dismissal of the reviews, that be dismissed.
Indeed,
Yes,
Justice.
that's
So
the
the effect is to reinstate
Yes.
the operation of the Sutherland order.
Yeah, thank you. So just to conclude then, on that argument, once you succeed, and if we're with you, there's no room for a declaratory order.
No, that wouldn't be required because it would be set aside on the basis of a finding of unlawfulness.
Thank you very much, Mr. Yanish.
As the court
That's it. Judgment is reserved. This court adjourns.
Please rise.